Dear leaders, honored guests, ladies and gentlemen, good morning. Welcome to the morning session of the fifth day of Hong Kong Legal Week 2025, hosted by the Department of Justice of Hong Kong, the first Guangdong, Hong Kong, Macao, Greater Bay Area Lawyers Forum. Welcome to all the guests on site and online who have been supporting us. Thank you very much. I am your MC today, Melody Kwang. Before we start our morning session, I hope that everybody can join me in memorizing those who lost their lives in the big fire last week. A lot of people were injured or affected. Let's extend our deepest condolences to all those who suffered from the big fire. We hope that the injured can get recovered quickly and the family affected can also get back to their normal life soon. In order to maintain the seriousness of the atmosphere, please refrain from applauding today. Please rise to observe a minute of condolences. Thank you. Please be seated. The inaugural forum themed Connecting the Greater Bay Area, Sailing Far and Wide, focuses the topics such as cross-border collaboration among lawyers in the Greater Bay Area. We look forward to valuable insights shared by legal experts and active exchanges among the industry professionals to jointly promote the development of legal services in the Hong Kong, Macao, Guangdong, Greater Bay Area. Now, shall we invite the Now, let's invite the Mr. Lin Tingguo, the GPS, Mr. Lin Guo, Secretary of Justice, GPS, to take to the stage and deliver an opening speech. Mr. Lam, please. Respected Mr. Chang, dear distinguished guests, ladies and gentlemen, good morning. First of all, on behalf of our Hong Kong SAR, Department for Justice, thank you very much for your coming to the last day of the event of the Legal Week 2025 in Hong Kong. Today, we have the theme of connecting the Greater Bay Area, sailing far and wide. And yesterday, it was the Constitution Day of the week. And we also hosted a forum to celebrate 35th anniversary since the release of the Basic Law. We understand that the Basic Law is the constitutional foundation for the development of Hong Kong to guarantee the prosperity and stable development of Hong Kong, so as to maintain the hub of international legal services. So with the support from all the parties in the society, as well as from the different levels of government, Hong Kong was ranked as the freest economy in the world and ranking number 3 by the international financial centers. Yesterday, through our discussions, we heard from different professionals and experts on the insights on dispute resolution, as well as how to help Hong Kong connecting to the world better. On the first day of the legal week, we started a sixth UNCITRAL Asia Pacific Judicial Summit, and later we discussed about the digital assets, trading finance, as well as the documentation requirements by the model law. And in the second day of the discussions, we invited over 40 judges from over 20 countries and regions, particularly from ASEAN and the Middle East, to join the discussion. And through their discussions, we talked about how to resolve the disputes arising from the application of artificial intelligence, as well as alternative distribution resolution. The third day of the discussion, we focused on the global governance initiative, as well as the multilateral international law application. And meanwhile, on the third day of a discussion, we also talked about the HCCH conventions, as well as the treaties applications in different regions and countries. We talked about the dispute resolutions among countries. Meanwhile, we also talked about how to resolve the disagreements and the disputes in commercial affairs and investment affairs. Meanwhile, we also heard from different experts, including experts from Korea, on resolving the disputes in the entertainment industry. And it is also the first time that we have included the LawTech matters into the discussions of our legal week agenda. This afternoon, we will have a special session dedicated to the discussion of LawTech-related matters. The Greater Bay Area has great potential of development, and it is also crucial for Hong Kong's future development. This afternoon, we're going to have a special session dedicated to the future growth by organizing different lawyers for this topic. The lawyers will join us from online and offline to share their insights, how we can cooperate with each other to realize the governance in the region in order to write a new chapter of growth commonly. And in the first, our Vice Dr. Honorable Chen Kuokwan, the Deputy Secretary of the Justice, will give us the first keynote speech this morning. And we have Mr. Chen Xudong, the Director General, Department of Justice of Guangdong Province, will also share with us the policies as well as the development strategies in Guangdong. Meanwhile, Mr. Tang Manle, President of the Law Society of Hong Kong, will talk about the legal practitioners' framework and the regulatory regime of GBA lawyers. And we have experts from Guangdong Province, as well as the other regions, to share with us about some specific topics. And we have the theme. We have a panel discussion to discuss about the unique advantage of a one country, two systems, three jurisdictions. And with the support from the central government, the practitioners in the Greater Bay areas conducted pilots, and the pilot will extend it to October next year. And we have also noticed that practitioners in the Greater Bay Area took examinations, and so far over 630 lawyers have already passed the examination and got their certification to practice in the Greater Bay areas. In this way, we can successfully reduce the entry barrier of lawyers for their practice in the region. And the Department of Justice also made an announcement that for those Hong Kong residents who have passed the practitioner examination in the Greater Bay Area can also get involved into the case resolution. And the category number extended from 5 to 237, that including unequal including the unequal construction competition, as well as the maritime disputes and so forth, so that lawyers from Hong Kong and Macau can also practice and deal with more different types of cases in the region. And Hong Kong and Macau and mainland China have different cultures in this regard. And with our insights, and I believe that our lawyers can understand the client's needs. And also the lawyers from Hong Kong and Macau, they have international vision, and the experts in common law. I believe that by allowing their practice in the Greater Bay Area, they can also showcase our unique advantage in Hong Kong. Now, today, in addition to our discussions on the heated topics today, I also would like to invite you to celebrate the forming of the first Hong Kong, Macau, Guangdong, Greater Bay Area Lawyers Associations. And last year, we have already initiated in the action plan. And one of the actions in the plan, we were going to set up such a alliance among lawyers in the region. In the working report by the chief executive last year, he also talked about how much importance the government has attached to the construction of the legal team in the region. And I must thank the great support from the Department of Justice, as well as the Guangdong Department of Justice, in enhancing our efforts in cultivating the lawyers in the region. We expect that we can work closer with each other so that we can promote the success of the pilot in the region, so that we can contribute our share to the construction of our legal success in the country. Finally, I must thank all my colleagues, all the supporting organizations, as well as all the speakers and the participants. Your participation is the key to the success of the Legal Week. I wish a great success to the event today. Thank you. Thank you very much. Please get back to your seat. Thank you once again. So today we are going to witness the establishment of GBA Lawyers Alliance. Now, shall we invite Madam Liu Changchun, the representative of the Preparatory Office of a GBA Lawyers Organization, Chairman of China Legal Service Hong Kong Limited, to share with us a brief introduction of the Alliance or GBA Lawyers Organization. Madam Liu, please. Mr. Lam, Mr. Zhang, dear guests, dear colleagues from the Greater Bay Area, good morning. Today we are gathering here in Hong Kong, in the Hong Kong CEC, to witness the establishment of the GBA Lawyers Organization. On behalf of the Preparatory Office of the GBA Lawyers Organization, I would like to extend our warmest welcome to all of you. I must thank you all for your support in preparing the establishment of the organization, particularly Hong Kong SAR, as well as the related departments. So setting up such a lawyers organization has been one of the talks speculated in the work report by the chief executive in 2024. Setting up such an organization is also a very important strategic step made by the country to enforce the strategic deployment in the Greater Bay Area. It is also a showcase of our capability and the level of services in financial services in the region, with the great support and promotion by the Department of Justice of Hong Kong, as well as the Department of Justice in Guangdong, as well as Guangdong Lawyers Association. Our preparation has been going forward successfully. And what inspired us the most is that our preparation office on the 16th of October made announcement of the member application. We have received a very positive feedback from all the lawyers in the region. Just within 2 weeks, close to 300 lawyers in the region have already finished their application. And this fully shows the high expectation and high passion that the lawyers have for the organization. Being a professional platform that connects the 3 regions, our organization undertakes 3 major obligations. First of all, we serve as a bridge. We organize lawyers from Hong Kong and Macau to participate events in mainland China, and so that they can exchange their ideas and practice in such events. Secondly, we help to tackle the difficulties. We collect information, analyze what their issues are, and help the lawyers to resolve these obstacles so that we can help them with their career path. Number 3, we are to serve the national strategy and lead all the patriot lawyers in Hong Kong and Macau to contribute to share in the legal construction with the foreign-related matters so that they can show the professional values. In order to fulfill these obligations, our organization have already planned a series of key tasks to work together with all the members. First of all, we will set up a professional exchange brand. Our organization will regularly organize the GBA Lawyers Forum, and we discuss around the trading rules, the data analytics, as well as knowledge exchanges. And we also organize different exchanges among lawyers in the 3 regions so that we can help them to understand their policies better, to connect their business better, and build up our brand in the region. Secondly, we will construct a training system for all the lawyers. We will set up a score mechanism, and we will work together with the professional training organizations in Hong Kong and Macau to set up such a training system by offering diversified courses and help the lawyers to improve their capabilities.
Thirdly, we will strengthen the professional research support and collect the key issues to carry out in-depth research and form special report for the reference of the relevant departments. And we will also issue the different practice handbooks and white papers on the practice status and the prospects of the lawyers of the GBA areas. Fourthly, we will have annual conference and also organize the thematic salons and the seminars and organize visits to the mainland and help lawyers in the GBA to be better integrated in the mainland legal market. Last but not least, I would like to express my heartfelt thanks again to the organizers, and also we together witnessed the launch of the GBA lawyer organization and hope every lawyers in the GBA can actively support and participate in our activities. And we will also open the application channel for members. And we believe our organization will live up to the expectations and give full play of the role of the bridges and the platforms and make contributions together to the GBA's construction and the country legal system. Thank you. Thank you. Ms. Low's introduction, please be seated. Since the Standing Committee of the National People's Congress authorized the State Council to launch of the pilot program in 2020, lawyers from the 3 regions have actively consolidated, strengthened, deepened professional exchanges, and jointly promote the GBA. And let's watch a short video of the Greater Bay Area Lawyer Organization establishment process. Please enjoy. The formal launch of the Greater Bay Area Lawyers Organization marks a step forward in professional cooperation among lawyers in the three regions. This is also an important step to promote the deep integration of the rule of law and the legal services in the GBA. Let us look forward to the organization playing greater role in the future, consolidating wisdom and experience of the lawyers from the three regions, working together to promote the development of the GBA, rule of law, and prosperity, and serving the overall development of the country. Before continuing today's agenda, I would like to remind everyone to refrain from clapping or applauding. Now, I'd like to invite the following guests to the stage for group photo. The Honorable Paul Lam, GBS SC JP, Secretary for Justice. Dr. the Honorable Zhang Guokun, SBS JP, Deputy Secretary for Justice. Ms. Liu Changchun, representative of the Preparatory Office of the GBA Lawyer Organization, Chairman of China Legal Service, Hong Kong Limited. Thank you. Mr. Cao Shaoji, Chairman of the GBA Lawyer Organization. Thank you. Mr. Zhao Zhenhua, Vice Chairman and the General Manager of China Legal Services, and also the Preparatory Office of the GBA Lawyer Organization, and Mr. Xiao Shengfang, the Chairman of Guangdong Provincial Lawyer Association, and Mr. Li Mingrui, and the Secretary General of the GBA Lawyer Organization. Mr. He Shijing, Vice Chairman of the GBA Lawyers Organization. Ms. Xu Kaiyi, Vice Chairman. Mr. Gao Dongli, Vice Chairman. Mr. Lin Zicong, Executive Committee Member. Mr. Yang Daming, Executive Committee Member. Mr. Lin Yongshan, Executive Committee Member. And Mr. Zhu Bolin, Executive Committee Member. And Mr. Chen Shaobing, Executive Committee Member. Thank you. Ms. Louis Xing, Executive Committee Member. Thank you. Thank you, everyone. Please follow our photographer's introduction. We also have a video. Please wait a moment. Is that okay? For the middle official photographer, thank you everyone. And the secretary and deputy secretary, please stay on the stage. And other guests, please be seated. Thank you. Next, let's welcome the following leaders and guest speakers to be on the stage and take a group photo. Mr. Chen Xudong, Director of the Guangdong Provincial Department of Justice. Mr. Qiu Xianzhe, Deputy Director of the Legal Affairs Bureau of the Macao SAR. Mr. Tang Wenlong, President of the Hong Kong Law Society. And Mr. Zhang Tianren, Member of the Executive Committee of the Hong Kong Bar Association, Senior Counsel. And also Ms. Tan Yunzhi, former Chairman of the Hong Kong Bar Association, Member of the Intellectual Property Committee of the Hong Kong Bar Association. And Mr. Wang Mingfeng, Barriers at the Double Road School. And Ms. Zhou Xuan, Vice President of the Guangdong Provincial Bar Association, Senior Partner of Jintian. And Ms. Chen Chu Dan, King and Wood, Melisons, Hong Kong. Mr. Yu Pei Heng and Lap Yu and Yu Pei Heng Law Firm Chief Partner. Ms. Fan Zhijun, Smithfield Law Firm. And Ms. Zhao Li, Judge of the 4th Civil Division of Guangdong Provincial Higher People's Court. Thank you. Please be ready for the group photo. Please wait a moment. And please hold your card on your chest and put away for a little while, and the photo taken will be better. Thank you. Video. Thank you. Let's double check with the cameraman. The photos and the videos were taken, right? Yes. Okay. Thank you very much. Thank you very much again. Please be seated. Department of Justice always committed promoting and improve policy measures to promote the close connection between the legal systems of mainland China and Hong Kong, and to facilitate the exchange and capacity building of legal talents. The DOJ will continue deepen the construction of the rule of law in GBA, further enhances Hong Kong's role as an international law and dispute resolution center, and also for the country's high-quality development and contribute to the development and assist mainland enterprises leveraging Hong Kong to go global. And today we are very honored to invite Deputy Secretary for Justice of Hong Kong SAR, Mr. Zhang Kokun, SBS JP, to give us a keynote speech. And the topic is about the Hong Kong's international legal hub, the partner of choice for enterprises in China and beyond. Mr. Chen Xudong, distinguished guests, friends, good morning. And today, I'd like to talk about the Hong Kong International Legal Hub, the partner of choice for enterprises in China and beyond, and sharing how Hong Kong and its unique advantages and how to leverage these advantages to assist the enterprises to go global and also attract the foreign companies. According to the World Competitiveness Annual Report 2025, Hong Kong's competitiveness ranked third in the world, and in terms of their business, and Hong Kong ranked number one. And the marketing and business efficiency, we ranked number two. It fully reflects the legal environment of Hong Kong, as well as the convenience of the independent judiciary system and a stable financial system. And Hong Kong has international legal position worldwide. And also we have the Resolution Center in the Asian Pacific region. In 2025, the legal index ranked 24th in the world. In terms of the regulatory enforcement, and we also improved compared with last year, reflecting Hong Kong's robust regulatory framework, which is highly recognized and enforced. It also provides a very stable environment for the business development, and we will continue to put forward our policy measures to strengthen Hong Kong as a super connector and a super value adder.
We're also helping the businesses from mainland to go global. The business in mainland, they are they are very good in different sectors and different businesses, and they have already got the capability to expand their business to the overseas markets. While they go global, they may need services, particularly internationalized services, and our service capabilities is right there to cater for those mainland businesses to help them expand to the international markets safely, so by leveraging our strength as a super value adder and a super connector. Our services can help the mainland businesses to set up their business in different markets and expand their presence. The report also pointed out that Hong Kong will work harder to leverage our capabilities and provide the international information services to the mainland businesses. As a part of my role, I am also looking after the legal affairs in this regard, particularly for example, the accounting services, financial services, and so forth. So we have also allocated services for resources for that. Regarding our our legal services, we have also been promoting our services to other businesses, to other countries and regions. We took the initiative to access the market in mainland to promote our professional services, including consolidating and publishing the successful cases for going global, to provide references to the local business in mainland. We also provide the matching services to the professional service providers in Hong Kong versus the businesses in mainland. We're also working hard in the Greater Bay Area to build up our capability of in the legal sector. So currently, we have already signed different agreements with different parties in mainland. For example, for the between Hong Kong and the mainland, between the courts, we have also signed different agreements, allowing that the verdicts or the decisions from the court can be accepted and executed in Hong Kong or in mainland accordingly. So according to those agreements, we have also made specific arrangements in order to enforce the execution of the decisions from the courts in Hong Kong and Macau. Meanwhile, since the measures of Hong Kong company, Hong Kong law, and Hong Kong company, Hong Kong arbitration measures being implemented, first of all in Shenzhen. Now, such arrangements have also been expanded to Zhuhai as well as the other cities, altogether 9 cities, so as it is the Hong Kong company. If it is registered and established in Hong Kong, no matter how much investment it has in mainland, then in terms of arbitration, the Hong Kong law can be applied in resolving the disputes. And in this way, we can help the Hong Kong businesses going into the mainland, and we can apply the Hong Kong's common law to resolve the disputes. Meanwhile, we can also use the Hong Kong common law to control the risks. And as usual, we can always choose Hong Kong as the arbitration destination to handle any disputes through our arbitration courts here. We're also working hard to set up a diversified dispute resolution mechanism in the Greater Bay Area. While helping the mainland businesses going global, we're also helping the foreign businesses coming to China by providing our professional legal services. We, together with Macao SAR, have been working together to streamline our arbitration procedures, and particularly in terms of the talent-related issues, so that we can have a arbitration mechanism in this region. We have already at least a register of arbitrators of Hong Kong, Macau, and mainland, so that we can conduct arbitrations in the region more smoothly. Before the end of the year, the Greater Bay Area Arbitrator Register will be published, and we are also cultivating and nurturing more talents to further enrich this register. Through working together with our counterparties, so we have already been working very hard on the mediation sector. So we also published the best practice of mediators in the Greater Bay Area, as well as relevant rules, regulations, and guidelines. In the fourth quarter this year, once again, we conducted evaluation and assessment of the mediators in the Greater Bay Area. Before the end of the year, we are going to update the mediators register for the Greater Bay Area. In the future, we will continue working hard to further improve our mediation platforms in the region by consolidating more mediators and more mediation organizations at the platform. In this way, we can lower the barrier of the dispute resolution for the parties. Number 3, we work together with the different courts to enhance our measures in nurturing talents. Last year in Hong Kong, we set up the IMED, and we have been working together with different ministries of China, as well as the different international organizations in Hong Kong and in the overseas. We have conducted a series of events. For example, in Hong Kong, there is in November last year, we conducted an event dedicated for the training of over 30 legal counsels from the SOEs to explore what are the legal issues that a Chinese business may encounter when they go global, what challenges there would be, and how we could counter to the challenges. Just now, our Secretary of Justice, Mr. Lam, already talked about our efforts in this regard. And because of the great support from the Department of Justice, as well as the counterparties from Macao, as well as mainland, now you can see that we are dealing with more cases. And altogether, we have already handled over 2,999 cases last year. And with our combined efforts, I believe that our professionals in the region can play a bigger role and integrate ourselves into our national strategy. We will definitely be ready to cooperate and follow the relevant policies and provide our assistance to the growth of the Greater Bay Area. According to the 2025 Economic Freedom Report, Hong Kong once again was rated as the first economic entity in the world, and Hong Kong's competitiveness is also the highest. The number of IPA, Hong Kong now is number one again by the number of IPOs here. And from these figures, you can see that Hong Kong SAR has been working hard to attract talents and businesses to come to Hong Kong and settle here. So facing with complicated international situation, Hong Kong will continue work hard to integrate ourselves into our national strategy and contribute our share to the growth of the country. Thank you. Thank you very much, Mr. Chang, for your remarks. Please get back to your seat. Next, shall we invite Mr. Chen Xudong, Director General, Department for Justice of Guangdong Province, to deliver a speech on uniting the forces of a rule of law, jointly building the future of a Greater Bay Area. Mr. Chen, please. So, Mr. Lam, Madam Liu, Mr. Chang, and the dear colleagues from the legal sector, dear friends from media, ladies and gentlemen, good morning. First of all, I would like to extend my deepest condolences to those who lost their lives and who suffered from the big fire. I have felt the deepest sympathy for those whose life have been affected by the Great Fire last week. Today, we are gathering here to attend the first Guangdong, Hong Kong, Macao Greater Bay Area Lawyers Forum. And just now, we have witnessed the establishment of the GBE Lawyers Organization. Right after the closing of the 15th National Games, this is once again another showcase of our synergy and cooperation between Hong Kong, Macau, and Guangdong. Here, on behalf of the Department of Justice of Guangdong Province, as well as the establishment of a GBA Lawyers Organization, I would like to extend our best wishes to both. And I would also like to extend our warmest gratitude to all the colleagues and friends. The construction of the Greater Bay Area was proposed by our president, and it is also a national strategy. In the past years, legal departments of Hong Kong, Macau, and Guangdong have been working closely with each other in promoting our laws and regulations, as well as legal services in the region. We have achieved a lot. As guided and supported by the Department of Justice in Guangdong, we have also been very active in promoting the openness to legal services from Hong Kong and Macau by allowing, first of all, the law firms in Hong Kong and Macau to set up their offices in Guangdong. We have also conducted pilots to allow lawyers from Hong Kong and Macau to practice in mainland China. And residents, we have also set up the lawyers mechanism, and lawyers from Hong Kong and Macau can be entrusted as legal consultants to the local firms in Guangdong. All those policies and mechanisms have been in place. Currently in Guangdong, we have already got over 600 lawyers from Hong Kong and Macau who have already accredited with the certificate of practice in the Greater Bay Area. And we have also the civil services, in total, over 370 of them from Hong Kong and Macau. We have 32 law firms or joint ventures in the Greater Bay Area, and we have 22 representative offices from law firms from Hong Kong. So with the combined efforts in the three cities, more and more lawyers from Hong Kong and Macau are dedicated themselves to the construction of the Greater Bay Area in Guangdong with the high level of legal services and a high level of professionalism. Not long ago, President Xi Jinping once again came to visit Guangdong. He stressed that we must never stop our efforts in promoting the construction of a Greater Bay Area. We must promote the soft connection with each other in law and regulation, and enhance our legislation as well as in law enforcement in the region, so that we can realize the full chain cooperation with each other in order to get ourselves integrated into the national strategy.
And the important instruction and a speech from the President Xi pointed a clear way forward to the construction of the GBA and also the legal exchanges and the cooperation in this region. In this forum, I would like to share with you 3 points. Firstly, we need to link Hong Kong and Macau and smoothen the channels of legal cooperation. In recent years, with the joint efforts of the legal department of the 3 places, we have already formed the combined field of rule of law. And one refers to the communication and collaboration mechanism. And we have already held 6 joint meetings. And N refers to other GBA cooperation platforms. For example, the GBA Organization Joint Committee Conference and the GBA Arbitration Alliance, and so on. And N can be extended to unlimited area. And according and based to the actual needs, and to be improved to a better level. And we hope that in the future, through this 1+N mechanism, to strengthen the cooperation in GBA and explore the more 3 places together, and the realization of the 3 places, and to promote soft connectivity. Secondly, based in the Bay Area, Greater Bay Area, we need to create a hub for the high talents. And GBA, there are a lot of high-level talents concentrated here. And this area, many lawyers have a broad international perspective, and they are familiar with a common law system. It is very important to serve the country's high-level opening up. and we are open to the outside world, from the policy opening up to the institutional opening up. And this is a very skilling process. And also, this is a process of transformation. And in the process, legal talents are particularly important. During this time, in Hong Kong, organized this GBA lawyer organization, and we will be joined this organization under the guidance of the Ministry of Justice, and to support these different services and activities of this organization. And just now mentioned by the Secretary of DOJ, and we just announced a new disclosure to have more Hong Kong, Macau, and the Taiwan residents, and as well as some lawyers to represent some civil cases in mainland courts. And we hope that the lawyers in this area will take advantage of this opportunity, and also the one country, two systems, and also the three legal educational combination, and to strengthen the connectivity and enhance mutual assistance and trust, and also build the high-level legal talents with large scale in GBA, and also inject innovative vitality into the construction of a GBA. And today we have representatives from the GBA different cities, and also the representatives of the judicial administrative systems. Therefore, we need to work together and join hands to make contributions. Thirdly, we also need to focus on the enterprise going global. And the theme of the forum is the Greater Bay Area selling to the overseas market. In recent years, the Department of Justice of Guangdong Province is also actively exploring the service of enterprises to go global, including serving in some enterprises, and also carrying out many activities and trainings. We also know that the Hong Kong SAR has recently set up a special task force for the service for the mainland enterprises for their going global. And this is a one-stop service platform. And we hope there are more professional forces, including lawyers, to provide market access to enterprises going global, and including the legal services and for the whole life cycle from compliance until dispute resolution, and let enterprises sell to the global market and with more confidence and security. So this is a very big picture. The connotation is very rich, and it's also a long way to cover. There's a lot of opportunities to seize, and we have to gather our strengths and the talents to fulfill the target. Dear colleagues, the legal system is an important integration development in the GBA. It's also a very important foundation for the high-quality development of a GBA. It's a very beautiful announcement of our future development, and this is a milestone of the promotion of the construction of a legal system in GBA. Let's work together on the track of this legal system to build the GBA as a first-class Bay Area with vitality and international competitiveness. Last but not least, I wish the forum a complete success, and wish the work of the Federation smooth sailing, and I wish all you a good health and a smooth career. Thank you very much. Thank you. Mr. Chen, please be seated. Next up, we'd like to invite Mr. Tang Menlong Roden, President of the Law Society of Hong Kong. The topic is Legal Practitioners, Framework and the Regulatory Regime for GBA Lawyers.
Deputy Secretary for Justice, Director Liu, Director General Chen, distinguished guests, ladies and gentlemen, good morning. It is my great honor to address you at the first Guangdong, Hong Kong, Macau, Greater Bay Area Lawyers Forum of the Hong Kong Legal Week 2025. Today, I will focus on legal practitioners' framework and regulatory regime for Greater Bay Area lawyers. The Greater Bay Area, comprising Hong Kong, Macau, and 9 municipalities in Guangdong province, is one of the most dynamic and innovative economic regions in the world. Under the unique structure of one country, two systems, 3 legal jurisdictions, our differences are not obstacles, they are opportunities. Diversity fosters specializations. Specialization accelerates collaboration, and collaborations enhance our collaborative international competitiveness. As the self-regulatory body representing over 13,000 solicitors, the Law Society of Hong Kong ensures that our solicitors comply with the laws, regulations, codes, and practice directions that underpin our profession. This year marks the 118th anniversary of our establishment. Throughout our history, we have remained committed to upholding the highest standards of professionalism, integrity, and service. The regulatory framework for Greater Bay Area lawyers was designed to create an institutional bridge among the legal systems of the mainland, Hong Kong, and Macau. In 2020, the General Office of State Counsel has introduced a pilot scheme, allowing eligible Hong Kong legal practitioners to take the Greater Bay Area legal professional examinations administered by the Ministry of Justice. Successful candidates can obtain practice qualifications in the 9 municipalities of the Greater Bay Area, enabling them to handle matters in Pacific civil and commercial legal matters of Chinese mainland law. In 2023, the Standing Committee of the National People's Congress extended the pilot scheme for another 3 years until 2026, including the welcome reduction of the required post-qualification experience from 5 years to 3. The Greater Bay Area examination has now been held 5 times since 2021, with the most recent examinations taking place in Shenzhen and Zhuhai in October 2025. Greater Bay Area lawyers enjoy the same right and bear the same obligations as lawyers in the Chinese mainland. Greater Bay Area lawyers are supervised by the Department of Justice of Guangdong Province and local judicial administrative authorities in accordance with the law of the People's Republic of China on lawyers. At present, as mentioned by Director General Chen, 630 Hong Kong and Macau practitioners have passed the examinations and obtained their lawyer's license. They have been certified to practice in over 170 law firms across 9 Chinese mainland cities in the Greater Bay Area, nearly 70% of whom are Hong Kong lawyers. These developments reflect the close ties within the Greater Bay Area legal industry. The goal is not just about numbers. They demonstrate deeper cross-jurisdictional collaboration and the rising influence of Greater Bay Area lawyers within the region. Hong Kong is China's only common law jurisdiction and the world's only bilingual English-Chinese common law system. Our legal system stands as a pillar of stability, certainty, and transparency. Greater Bay Area lawyers from Hong Kong offer unique strengths. Their common law training enables them to provide mainland counterparts with crucial insights into cross-border and international matters. This blend of legal traditions enhance the quality of service available to clients navigating multi-jurisdictional environments. Hong Kong's legal sector also serves as an inspiration in shaping the development of legal frameworks within the Greater Bay Area. A notable example is our Professional Indemnity Scheme, PIS. The PIS is a statutory scheme that provides indemnity against civil liability arising from legal practice, protecting both the public and law firms while reinforcing professional accountability. Before the Greater Bay Area lawyer regime, Hong Kong solicitors could only serve Greater Bay Area clients from Hong Kong. Today, Greater Bay Area lawyers may provide service directly within the 9 mainland GBA cities, not to compete with Chinese mainland lawyers, but to act as a super connectors and super value adder, linking Chinese mainland enterprise with global markets. Policy developments continue to enhance opportunities for Hong Kong lawyers. The Second Amendment Agreement to the CIPA Agreement on Trade in Service, implemented in March 2025, introduced significant institutional innovations. Among these are 2 key measures. Hong Kong investor enterprise in Shenzhen and Zhuhai may now adopt Hong Kong law in their contracts. And enterprise in all 9 Greater Bay Area municipalities may choose Hong Kong as the seat of arbitration. These measures strengthen the legal advantages available to business and reinforce Hong Kong's status as a leading international arbitration center. Meanwhile, the Regional Comprehensive Economic Partnership, RCEP, the world's largest free trade agreement, has reshaped global trade since its entry into force in 2022. While Hong Kong has not yet joined RCEP, the Hong Kong Special Administrative Region government submitted its application for accession in early 2022. Once Hong Kong becomes a party to RCEP, mainland enterprises are expected to expand their presence in the city to leverage our low-tax regime, common law system, and free flow of capital. This will in turn create substantial new opportunities for Greater Bay Area lawyers who are uniquely positioned with both regional familiarity and international perspective. The Law Society has been actively fostering the development of Greater Bay Area lawyers. In 2023, we established the Greater Bay Area Lawyers Subcommittee to provide a platform for exchanging views on Greater Bay Area practice and enhancing professional development. This subcommittee also organizing training, seminars, and activities to deepen knowledge of Greater Bay Area related issues and encourage the profession to seize emerging opportunities. In conclusion, Hong Kong legal practitioners serving as Greater Bay Area lawyers embody a bridge built on mutual respect, shared values, and complementary strengths. Our role within the Greater Bay Area is defined not only by legal expertise, but by our capacity to connect systems, people, and markets. Looking ahead, we will continue to strengthen regulatory cooperation, enhance collaboration, and work closely with our counterparts across the Greater Bay Area to advance our shared goals. Thank you.
感谢汤会长的精彩演说，谢谢，感谢你的分享。
Thank you very much, Rodden, for your sharing. Please get back to your seat. Our next speaker is Mr. Jonathan Chung, SC Council Member, the Hong Kong Bar Association, to talk about dispute resolution practice in the Greater Bay Area, current mechanisms, challenges, and innovative pilots. Mr. Chung, please.
Secretary Lam, Mr. Chen, Deputy Secretary for Justice, friends and leaders, I'm very honored to share with you the latest update on dispute resolution in the Greater Bay Area. Today, I'm going to focus on 3 topics. The first is the system for legal verification, and secondly, challenges facing cross-border cases, and thirdly, the latest development of enforcement of mainland judgments in Hong Kong. Right now, in the Greater Bay Area, legal verification relies on traditional means, that is by the parties concerned to provide expert opinions or to commission expert organizations to carry out investigations, but the hiring of external experts is very costly and time-consuming, and also the procedures of verification always cause delay in the handling of court cases. The Guangdong court in January 2025 promulgated the white paper on protection of legal services in the Greater Bay Area, and in it contains 2 measures. That is, it launched guidelines on judicial rules on handling commercial disputes in Hong Kong and Macau. That is to provide parallel judicial proceedings and also have extraterritorial evidence procedures so as to provide clear guidelines for judges in handling related cases. And secondly, it agreed to set up a platform for legal verification for the cases in the Greater Bay Area. It actually covers legal texts, the number more than 30,000, and also is highly professional with a database on more than 30 legal experts who are carefully selected in Hong Kong and Macau area, and the measure is intended to expedite the process of verification. Hong Kong courts in handling Greater Bay Area cases, it now can benefit from the newly established platform. But for now, it really relies heavily on the traditional approaches. We do hope that Hong Kong can set up a similar expedition mechanism or have articulation with the Guangdong platform so we can share resources with the Greater Bay Area that can speed up the process of legal verification and also foster uniform, accurate understanding of the legal differences in Hong Kong and the Greater Bay Area and to minimize disputes. In handling cross-border cases, a core challenge is the delivery of judicial instruments. And since 1999, there was actually regulation put in place, but there's room for improvement in the success delivery of judicial instruments. The reasons for the failure of delivery is the insufficient address and also unknown locations of the person the document is supposed to deliver to. The Department of Justice in December 2023 on arrangements for delivery of judicial instruments proposed to LexGo a new mechanism to optimize the delivery and also to have multimodal delivery. It contains the following approaches. Firstly is to enhance or increase the modes of delivery and allowing the party concerned in Hong Kong with approval from the court to mail the instruments by mail in the Greater Bay Area or to submit to them electronically. And right now, Hong Kong courts have not given approval for substitute delivery methods, but the new proposal will allow the parties concerned to ask the Hong Kong court to commission mainland courts to deliver the instruments. And since the notice was announced, and there can be a period of validity for the delivery. And under the new mechanism, the Supreme People's Court and the High Court in Hong Kong can, through consultation, authorize various intermediate People's Court or primary court to have direct communications with the High Court in Hong Kong concerning the delivery of instruments to minimize the time concerned and speed up the handling of the case. Another core challenge is the collection of evidence in resolving cross-border cases. In 2025, the case concerning Tenhao International Holdings Limited, it is actually a landmark case. It involves the Tenhao liquidators trying to obtain the relevant documents in Shenzhen. But in the mainland, there are rules banning the transfer of those documents out of the country. And whether the Tenhao International Holdings can it obtain the documents it want? The Court of Final Appeal agrees that Hong Kong court can issue instructions or requests to the mainland courts on two principles. Firstly, Hong Kong court has the right to issue requests to mainland courts for assistance. And mainland regulations ban the transfer of documents outside of the country. But the regulations, the principles is that there could be the room for discussions on a case between mainland and Hong Kong courts. So if mainland courts can give the approval, then Hong Kong court should be authorized to make the request. And there's also the principle that the scope of the mutual request arrangement. And there is this definition that the documents to be transferred out of the country should be restricted to documents which are actually needed for the case, for the legal settlement of the case. And also the mutual arrangement is seen as purely an administrative arrangement. So Hong Kong court can issue a request to the mainland court to ask the parties concerned to obtain documents previously banned, and also there can be better collaborations legally between Hong Kong and the mainland. And in enforcing mainland judgments, the latest development is that there is new arrangements that took effect on January 29, 2024, on mutual recognition and enforcement of judgments. This is a replacement of the old system, and it also provides for a more comprehensive and more convenient mutual recognition of judgments. In 2024, January 25, there's also Practical Instruction 38, laying down the details for the procedures of mutual recognition of court decisions. The new arrangements have taken effect, but the Article 597 remains applicable to judgments handed down between August 1st, 2008 and January 29, 2024, because the validity of the judgment was supposed to be valid for 2 years. Therefore, the relevant article will remain in effect for the time being. In Beijing Renji Real Estate Development Group Company Limited versus Zhu case, and this case led to a careful explanation of the provisions concerning enforcement of mainland judgments. So this case involved the interpretations of the main contracts, which means the mainland courts could have the final say over the mainland contracts. But based on Article 597, the contentious points of the clause concerning the jurisdiction of the main contract, whether it can be incorporated into the guarantor contract, and whether assistance can be sought from mainland court. The Court of Appeal ruled on October 2nd, 2024, that it actually provide for the rule that the plaintiff cannot take the case to the Court of Final Appeal. With the articulation of new and old systems, there are 4 points that you can take note of. That is, you need to precisely decide on which case should be governed by which articles. So if the mainland judgment was ruled or was handed down on or after January 29, 2024, then the new provisions will apply. But if it's a decision made before that day, then Article 645 or 597 would continue to be effective. So there's also a time limit for applying for mainland judgments. You need to have preparations and adequate preparations for obtaining the legal materials needed. And you need to pay close attention to the development of the judicial arrangements. I'm sure there could be more case law coming up concerning the implementation of the cases under the new provisions.
And in light of experience, it might be amended. We have to maintain our concern about all these developments. It will be facilitating our processing of these cases. Overall, the dispute resolution system in the GBA has been undergoing transformation. We have seen a lot of positive developments there, and the interface of the regulatory system is still facing challenges. The ascertainment system, all of these still have room for improvement. We have to avail ourselves of the existing system while seeking to improve the system on a regular basis. We should abide by all the requirements. We should exploit, we should take full advantage of the mutual assistance, and we should seek to improve the dispute resolution system and make a professional contribution to the system. Thank you very much.
Thank you, Mr. Zhang's valuable sharing. Please be seated. Thank you. Let's welcome Judge Zhang Li in the 4th Civil Division of the High People's Court of Guangdong Province. She will talk about innovations in the regulatory framework and the judicial practice concerning choice of law for Hong Kong and Macau invested enterprises. Distinguished Honorable Secretary Lam and the Deputy Secretary Zhang and Mr. Chen. Speakers, guests, good morning. It's a great honor for me to talk about the innovations in the regulatory framework and the judicial practice concerning choice of a law for Hong Kong and Macau invested enterprises. And we also talk about this impact and the important understanding of this framework. And there are 4 contents. And first of all, I will talk about the significance of this agreement and this regulatory framework and the judicial practice. And secondly, I will share with you the understanding of the main content of the approval. And finally, I will talk about implementation. And regarding the background, and Han Feizi once said, law governs with time and the proper time and help the governance to be more stable. And the governance and the appropriate law will lead to success. It can be said that innovation of rules for legal choices for Hong Kong and Macau investment enterprises is driven by the practical needs. And there are more Hong Kong and Macau economic entities have chosen to invest in the mainland. And by the end of 2024, there are nearly 200,000 foreign invested enterprises registered in GBA, and 92% of them are related to the Hong Kong and the Macau invested enterprises. At the same time, Hong Kong and Macau investors hope to break through the limitations of the traditional legal framework, and they will have more choices and for the arbitration and also different legal procedures, supporting Hong Kong and Macau invested enterprises to resolve disputes, and is a key need in this area. And in December 2016, the Supreme People's Court issued opinions on providing judicial services and guarantees for GBA. And in 2022, and another document was issued to support and guarantee the construction of a Qianhai Hengqin, proposing to support the Qianhai Court and the Hengqin Court and to explore a mechanism for identifying extraterritorial laws and allow Hong Kong-funded and Macau-funded enterprises registered in these places to choose the different laws to resolve disputes. And after that, in February this year, the approval of the official announcement has been established. On the same day, the Ministry of Justice of the Supreme Court issued a notice on giving full play to the role of arbitration function. And this agreement and approval is of a milestone significance. First of all, it has achieved an institutional breakthrough in the legal options. And as Deputy Secretary Dr. Zhang mentioned, it enables Hong Kong and Macau invested enterprises to flexibly choose the applicable law and arbitration venue according to their needs. Secondly, it promoted in-depth development of connection between the mainland and Hong Kong and Macau, enhanced the credibility of the mainland judiciary to Hong Kong and Macau parties. Thirdly, it lays a solid foundation for creating a preferred place for international commercial dispute resolution, and also has a great influence in the competitiveness improvement of the GBA in the international commercial dispute resolution. Finally, it also promoted the construction of a market-oriented legal and international environment in GBA, and it enhanced the information, optimized the business environment. From the content of the document, and there are three aspects: the legal selection of the identification criteria and the place of arbitration, and also the approval of the definition of the standards. And it is said that enterprises registered in the mainland, in full or in part, or natural person enterprises or other organizations invested by Macau or by Hong Kong can be recognized as Hong Kong-funded or Macau-funded enterprises. And the Hong Kong and the Macau shareholders of these companies, and they will also have the choice to select the laws of Hong Kong or Macau and the place of the arbitration. In terms of the arbitration seat, the approval set, and both parties can choose mainland or Hong Kong or Macau as the seat of the arbitration. It's very surprising that half a year after the implementation of this approval, the Shenzhen Intermediate People's Court of Guangdong Province has made rulings in favor of Hong Kong-funded enterprises. So this is a witness of an important moment of the implementation of approval. And the Guangdong Court will also take the implementation and to promote the construction of a more open legal application system and also more diversified dispute resolution mechanism. First of all, they will improve the more systematic and professional mechanism for identifying extraterritorial laws and enrich the GBA foreign law platform. And also the foreign-related judgment documents search platform. And there are about 30 Hong Kong and Macau experts. And on the basis of 8 batches of 120 typical cases on this platform, and they will be published in Chinese, English, and Portuguese to provide vivid guidance. Secondly, we will build a more open and inclusive legal application systems. And to summarize the disputes resolution and strengthen the study of comparative law between the mainland and Hong Kong and Macau. And we'll also solve the cross-border disputes in accordance with the law to meet the development needs of the legal integration in the GBA. Finally, we will create a more influential preferred place for international commercial dispute resolution, effectively promote implementation of a Hong Kong-funded and Macau-funded enterprises arbitration, and support eligible Hong Kong and Macau enterprises to choose to apply Hong Kong and Macau laws or use Hong Kong and Macau as seat of arbitration, and support Guangdong and Shenzhen to carry out the pilot construction of the international commercial arbitration centers. At the same time, and they will also support the investigation order to assist the commercial arbitration and the methods of investigation and the service, as well as the evidence collection, and to promote the effective connection between mediation and arbitration in the 3 regions, and optimize the platform of South China Hong Kong Court and of the international arbitration. And we believe with the full implementation of the approval, and there will be more innovative measures in the GBA, we will stick to the foundation of a one country, two system, and use the power of the 2 wisdoms to provide a strong legal guarantee for the construction of a new system of GBA. Thank you very much for your sharing. Please be seated. Now we'll have a tea break, and I welcome all of you to the outside place to enjoy some refreshments. And we will start our forum at 11 o'clock. At the same time, we also invite you to visit the legal technology in S226 and 227. And the exhibition is to show the latest different technology services. Please note that. Please bring your personal belongings with you. And the online participants do not need to log out. We will see you at 11 o'clock.
各位来宾，我们即将开始，请各位尽快就座。谢谢各位的配合，谢谢。各位嘉宾，我们下一节的论坛即将开始，请各位马上就座，谢谢，请大家马上就座。 各位嘉宾，我们马上开始。请各位就坐，我们马上就开始下一个论坛，感谢。各位嘉宾，女士们。
Dear distinguished guests, ladies and gentlemen, welcome back to the panel discussion of the first Guangdong, Hong Kong, Macao Greater Bay Area Lawyers Forum. So please be seated. We're going to start our panel discussion. Ladies and gentlemen, dear distinguished guests, welcome to the panel discussion of the first Guangdong, Hong Kong, Macao Greater Bay Area Lawyers Forum. Just a reminder, please refrain from applauding or clapping to maintain the seriousness of the conference, to show our condolences and respect to those who lost their lives in the big fire last week. Now, shall I invite the moderator and panelists to come to the stage and share their views on different ideas on the unique advantages of the one country, two system, three jurisdictions, the GPT lawyers facilitating enterprises to go global. So please be reminded, we will have a Q&A session after the panel discussion. Guests online and on-site, please feel free to submit your question by scanning the QR code, and we're going to try to answer your questions after the panel discussion. Now, we have the honor to have Mr. William Ming Feng Wang, SC BBS JP barrister from the four chambers, to be our moderator. Please come to the stage. We have also got the honor to have 5 speakers. First of all, we have Ms. Candy Chen, the partner and head of the Hong Kong IPO practice, King & Wood Mallesons, Hong Kong. We also have Ms. Zhou Xuan, Vice President, Guangdong Lawyers Association, Senior Partner, Jing Tian and Cong Gongcheng. Ms. Zhou, please. We also have Mr. Zhou Fan, Managing Partner of China Offices, Herbert Smith Freehill Kramer. We have Ms. Wendy Tam, SC SBS JP, former chairman, the Hong Kong Bar Association member, Committee on Intellectual Property of the Hong Kong Bar Association. And finally, Mr. Henry Yu, principal partner, Aaron Y Law Office, and Henry Yu and Associates, member, Department of Justice Advisory Group of Guangdong, Hong Kong, Macao, Greater Bay Area Lawyers. Now the floor is yours, Mr. Moderator. Thank you. Thank you for coming here for this panel discussion.
The topic for the panel discussion is unique advantage of one country, two systems, and the 3 jurisdictions. As we know, in Greater Bay Area, and we have sufficient law talent reserve because we have the common law here and also the civil law in the mainland, as well as the Portuguese-speaking law in Macau. Now our country is encouraging the enterprises to go global, and it used to be the attraction from the foreign investment. Now the focus is going global. So under this trend, the 3 jurisdictions and how to the talents in this place to help our enterprises to go global, especially. For example, Hong Kong is very professional in financing services and also cross-border investment services. In addition, no matter it is in the country's 15th five-year plan or these high-quality productivity and also the protection of intellectual property, and this protection of IP is very important. In addition, new type of investment, for example, the cryptocurrencies and the virtual assets and the technology assets are also very helpful for these enterprises to go global. As a moderator for this panel, the most important task for me is to ensure that everyone can go to lunch at 12:45. So I have to manage the time well. First of all, I'd like to invite Ms. Candy Chen, partner and head of Hong Kong IPO practice, King & Wood Mallesons, Hong Kong, to talk about leveraging Hong Kong to go global, establishing a gateway to global financing. Thank you, Dr. Wang. Distinguished leaders and colleagues. And most of the seminars we joined and actually are not for our professional colleagues. So I think this is a very good opportunity today to talk about our own issue and also the common opportunities and how to leverage Hong Kong to go global. My hometown is Zhaoqing, and I was born in Hong Kong, but I think I'm also with the same homeland in the GBA, and I did a lot of listing projects, including some overseas companies listed in Hong Kong. And we also see this very good momentum of the capital market development in Hong Kong. Myself is a Hong Kong lawyer, and I'm also the first batch of the lawyers in the GBA. That was in 2022, and there are about 300 colleagues have passed the examinations. So 600 lawyers have already been registered as the lawyers in GBA. And we can talk a lot on the cross-border legal services. And King & Wood Mallesons is very special, as you know. And our law firm is established in China. And this establishment was 30 years ago. And we are also the first batch of the law firms to be registered in mainland China. We are also the largest law firm in Hong Kong, and many projects are integrated of the three jurisdictions. So how do we leverage those business opportunities to integrate the lawyers of the three places? In terms of IPO and also litigation, and we are actually inseparate from civil law in mainland China. But how do we use our professional talents in the common law for the problem solvents in our clients' projects? Okay, this is a kind of advertisement. I used 3 minutes for this advertisement. And this is a kind of introduction and simple an overview of the legal system of the three jurisdictions, which have already been mentioned before. And the legal systems are different, and it will affect the enterprises going global. If we visited Hong Kong or visited Europe and the US or Middle East, or for example, the Egypt or other places, the legal systems are all different. And in Hong Kong, the lawyer in Hong Kong, and we have this cross-border legal system capability. And this is a very good advantage for all of us. And dispute resolution was just mentioned by Mr. Zhang and also Mr. Zhao. So I won't go into the details. I'd like to talk about, for example, we have a bilingual legal system. And actually, there are three languages, or trilingual legal system. We also have a Cantonese. And many of our local people in Hong Kong speak Cantonese. And in our school, we also started learning Mandarin. A lot of people are speaking Mandarin nowadays. So if we can have a good language proficiency, and this will better serve the mainland enterprises. And in in Hong Kong and the Cantonese, we speak Cantonese, and the traditional Chinese is the written language, and English is also our official language. And English is very important in terms of language training. It's one of our focus in the future. And we have already formed this bilingual legal system in terms of the provisions and the terms. And in terms of the overseas financing platform, last year I talked about this topic too. And last year, Hong Kong's market was not good, but this year, and the IPO's pool has already reached 240 billion. And after December, it is expected to about 280 billion. And we are the #1 worldwide. There are a lot of IPO projects. So why we have this kind of a good capital market? It's related to the support of our government, and also we see a lot of overseas family and officers have set their headquarters on offices in Hong Kong. And Hong Kong has already surpassed Switzerland, become the largest family asset management place in the world. And they will definitely keep the money in Hong Kong. In addition, many large international funds and hedge funds have set up offices in Hong Kong. And many financial products or other products are diversified. It's not only about IPO. We also have products, for example, in August this year, and we just issued the first stablecoin policy. And after 1 year's virtual currency, digital currency regulations. And it's related to the operation of the modern enterprises in the AI era. And what are the advantages of Hong Kong, and what's the overall development of the capital market? As a lawyer, we are based on evidence. And from this page, and in your right hand, side, and this is the figures of the IPO application. And our stock exchange has received 400 applications as of the end of last month. And we can also search the annual report of Hong Kong Stock Exchange and for the past 10 years. And for example, in 2023, there are about 100. And this year, as of the end of last month, 400 companies have submitted the application. So this year's performance is brilliant. And we also heard that some investment banks, they are very busy and they apply to different cities and every day. And the relevant lawyers are very busy as well. And we will also help them to do these prospectus showcasing the activity and also this busy capital market. Many listed companies, assets, and the shareholders, if they are relevant, and so you see we have some time gap between the H share and A share. And next year, we think there will be a very important year for the IPO for those companies in Hong Kong because they want to speed up this listing procedure. And this is also good to the entire capital market. In every listing procedure, we need investment bank as well as lawyers, and we need different size of the professional support. For example, the issuer lawyers and overseas issuer lawyers, domestic brokerage lawyers and overseas brokerage lawyers. Many times, such as some Chinese firms, and we will have about 4 law firms in one project. And this is a very good opportunity for all people. In the A-share market, we see that it's not as active as the IPO in Hong Kong, and we also seek opportunities there. And 3 companies plus Kelly's has raised more than 100 billion within a year. And many A-share companies, they are queuing for the listing in Hong Kong. It's about a quarter of those listed companies are A-share companies, and they want to achieve an A plus H listing. So both foreign investment and the capitals as well domestic capitals will be remained in Hong Kong. And next year will be the big year for the capital market. There will be more opportunities. We hope that there will be more enterprises from GBA to be listed in Hong Kong. Thank you. Thank you, Ms. Chen. Talk about the optimistic opportunities and the positive signals. The capital market is very active, and we gained the #1 in the IPO worldwide. And this is a very good, important function from our legal system.
Our next speaker is Mr. Zhou Xuan, Vice President, Guangdong Lawyers Association, Senior Partner Jing Tian and Gong Cheng, to talk about new initiatives for cross-border capital in GBA integration. Ms. Zhou, please. So thank you, William. Mr. Lin, Mr. Chen, ladies and gentlemen, good morning. I am Zhou Xuan. I am from the Guangdong Lawyers Association, and I am also a senior partner for Jingtian and Gongcheng law firm. I'm going to talk about some new initiatives for cross-border capital. We just had the Constitution Day, which makes our discussion today even more meaningful. Being a lawyer from Guangdong, I have been working in the cross-border capital market, particularly IPO and MLA, for over 26 years. I have been serving over 110 businesses such as BYD, Xiaomi, and PopMart, and so forth. When they got listed in Hong Kong, when they came to Hong Kong for fundraising, I served them. So one thing I have felt is that Hong Kong, being the financial institution, financial center, is the first and the best stop when Chinese businesses going global. As Dr. Zhang said, that Hong Kong is the best affiliator for the mainland businesses. I would like to share with you some of the observations I have. First of all, in the guideline, that is the outline development plan for the Guangdong, Hong Kong, Macau, Greater Bay Area. And we have found that the investment and facilitation, and as well as the trade liberation and facilitation of people and goods flows and so forth. In these areas, the government encourages the more cooperation between the regions in the Greater Bay Area. And more importantly, during the 15th five-year plan, it is stressed that we are to enhance and elevate high-quality growth of the GBA, specifically in terms of the integration of the cities in the Greater Bay Area. What initiatives do we have? So as Madam Chen said earlier, that the government has issued a lot of policies. And because of the policies and because of such initiatives, more and more companies are coming to Hong Kong for IPO. In this table, you can see I have listed some new policies and initiatives here. In March 2023, you can see that the CSRC, the interim measures for the administration of overseas securities offering and listing by domestic enterprises, was issued. And in April 2024, CSRC issued another initiative, which is the notice of 5 capital market cooperation measures with Hong Kong, including further optimizing the mutual benefit access mechanism and supporting leading mainland enterprises to list in Hong Kong. And in August last year, the opinions of further advancing the Shenzhen pilot comprehensive reform to deepen the reform and innovation and expand, open up, was also issued by the State Council. And particularly, we can see that this is the biggest support and encouragement for businesses to get listed in Hong Kong. Hong Kong was very responsive. And in last October, SFC and Hong Kong Stock Exchange issued the response immediately, saying that a joint statement of Hong Kong Securities and Futures Commission and the Hong Kong Stock Exchange on the establishment of a fast-track approval. And in May this year, the SFC also issued a new document. It's about the joint announcement of the Hong Kong Securities and the Futures Commission and the Hong Kong Stock Exchanges of the official launch of Tech Enterprise Expresses. So when you apply, you don't have to disclose. When you put up your application, so you can just, you don't have to disclose such application to the market. So that is called the 18A and 18C chapters. So these are new initiatives and very good initiatives which have brought the boom of IPO applications in Hong Kong. So far in this year, 90% of the successful IPOs, I should say 89% of the successful IPOs this year is from mainland. So in addition to the over 90 successful IPOs, Hong Kong Stock Exchange is still reviewing the rest of the IPO applications, in total over 300 of them. So putting these two figures together, that is over 400. This is a historical high. As a comparison, I can share a piece of data to you. So in the Asian market, so how many applications for this? So this total number of applications this year is more than the total number in the past 10 years. So this shows that these new initiatives are really effective. And in addition to these figures, let's look at another important indicator, that is total fundraising amount, which is also very shining, very eye-catching. So just remember, some people felt that it was difficult to get to your fundraising in Hong Kong. However, today, this year, you have to refresh your memory. The total amount of fundraising through IPO in Hong Kong is more than doubled, also creating a historical high. Is the over 182.9 billion, and in this amount already exceeded that of the Nasdaq and the New York Stock Exchange or any other exchange in the market. So from these 10 companies, you can get to your conclusion whether it is still difficult to fund your raise. If you look at these top 10 companies, from CTL to Foshan Haitian flavoring and food company, as well as the Michel Group, actually, we have been serving 7 businesses out of these 10. One thing we have felt, obviously, is that the overseas capital has got a very high level of passion and recognition on Chinese businesses. And if you look at the valuation given by the Hong Kong Stock Exchange to the Chinese businesses, it is also a very good reflection that the Chinese businesses are really good and they have confidence on Chinese economy. In addition to the capital market, we have seen some other initiatives to provide convenience to the investment. For example, the QFLP in Shenzhen as well as QFLP in Nansha. QFT is now changed into a more flexible system, and in Nansha, it is one of the leading pilots. It is the double Q, the QFLP and the QDLP. And the foreign exchange registration is now only taking within 1 day time, and the approved amount is over 24 billion US dollars. For those who need capital for cross-border business, this is definitely very appealing. So is the system good? Actually, the data can speak. So KFLP, the total size is 7.7 billion US dollars. 70% of the overseas investors are from Hong Kong. As of the end of April this year, the total approved amount of double Q mechanism also doubled, reaching 300 billion yuan RMB, and the capital is now directing to such as biomedical, AI, and so forth. And number 3, let's look at the capital settlement, what new initiatives we have. So for the new financial settlement measures, the Qianhai Unified Domestic and Foreign Currency Account activates the capital flow. So by this unification, it across the border between RMB and US dollars, and improving the efficiency of capital utilization as well as the foreign exchange risk control. So within one capital pool, a business can coordinate the use of different currencies to reduce the finance cost and the time cost. So this result is also very eye-catching. As of the end of July this year, 55 MNCs have already took part in the pilots of this unification of capital with a total amount of capital 350 billion US dollars. So all these measures provide great convenience to the capital flow in the Greater Market, in the Greater Bay Area, and through Qianhai, through Nansha, and through Hengqin. foreign investors can invest in the emerging sectors in mainland, and also local businesses can also use Hong Kong as a springboard to go global. One important role is the lawyers. Actually, so we have the dual frame-based legal talents. In the past few years, Guangdong Lawyers Association, under the guidance of the Department of Justice of Guangdong, we have spent a lot of time and energy in cultivating our own talents, trying to covering all types of services. So please follow our foreign-related legal service network. So as of the end of November this year, over 600 lawyers from Hong Kong and Macau have been accredited to practice in Greater Bay Area. A lot of them have been practicing in 9 cities in Guangdong province. So with the common prosperity, lawyers are playing more and more important role because legislation needs our participation. We need innovation in their legal frameworks. So serving the Chinese business in going global, we need the participation from lawyers from Hong Kong and Macau, from cross-border investment, foreign overseas investment, M&O, as well as IPR. IP protection, we need the involvement of all the lawyers from Hong Kong and Macau in order to realize the compliant growth. So we are supplementary to each other. We are different. It's because of the difference we have. That's why we need to cooperate. As Mr. Chen said, that the connection GBA is the best way we have in our cooperation. This is a new era, and we have new opportunities. We hope that in Greater Bay Area, we can work together to embrace a better future. Thank you very much. Thank you very much, Ms. Zhou. Ms. Zhou is definitely is really good in time management. She's also a very good marketer. She not only marketed Hong Kong's finance fundraising platform, she also promoted her own firm. So among the top 10 IPOs, she has been serving over 7 of them. And she also talked about the history as well as the businesses that the Hong Kong and Macau lawyers can have. She is really indeed a very qualified president of the association. So we have heard 2 speakers. And in Hong Kong, we don't have IPO only. We have some other very good services to serve the cross-border investment in risk management, so on and so forth. Our next speaker is from a foreign firm. She is Mr. Jojo Fan, managing partner of China offices, Herbert Smith Freehills Kramer, to talk about the legal risk management in cross-border investment and transactions. Ms. Fan, please. Thank you. Thank you very much, William. So talking about the time, I feel kind of pressure. I try to manage time well. So good morning. I'm Jojo Fan, and I'm the managing partner of China offices Herbert Smith Freehills Kramer. And it is my honor to be here and share with you some of our experience and insights on legal management in cross-border investments and transactions, and how to mitigate and control the risks. So Hong Kong is a super connector, connecting the mainland and the world, and Hong Kong is also playing a very important role as a bridge. And in the GBA development plan, Hong Kong's role is very obvious in terms of fundraising, in terms of overseas investment. Hong Kong has a big role to play. Hong Kong has a very prudent common law legal framework. We are bilingual. We have lawyers with international vision and exposure, and we have international arbitration centers as well as the IMED. So no doubt, Hong Kong is now becoming a center in resolving commercial disputes.
And with the growth of the cross-border investment, as well as the Chinese enterprises going global, and we also face the increase on the legal risks. So what kind of special attention we need to pay to the particular risks? First of all, it's about the contractual risks. If the terms of the contracts or one party of the contract cannot or fail to fulfill the contract, this will lead to the contractual risk. And how to avoid this risk? Saying is simple, we must have the accurate terms. Drafting the contract in a clearer way, and there must be very clear language on the terms and the conditions and the delivery times and the performance standards, and it needs the help of the lawyers. For example, in common law, we often heard that one party must make the most reasonable effort. It sounds a little different from the other jurisdiction legal system. But I won't elaborate on this regard because of the interest of time. And another thing we need to pay attention is about the agreement and the fixed liquidated damages and also the limit on compensation. All these terms must be clarified in drafting the contract. Of course, and people will also need to settle down the exit terms, or what kind of terms can be terminate this contract, and all these procedures and the terms must be clear when drafting the contract. Also, a very hot topic. It's about electronic signature. Electronic signature is different from the traditional signature. You print a piece of paper, and sign your name there. This is a traditional way. Nowadays, when you, for example, swipe your card, they will give you a screen, and you will use the electronic pen to sign on it. Or there is some special electronic signature platform. The electronic signature, what kind of requirements in Hong Kong, or what kind of agreement and contracts is allowed to use this? And in Hong Kong, we have electronic transaction ordinance to regulate this kind of a signature. For example, some minutes of a company or articles of association of a company, and you can use the electronic signature. And another one, for example, we called it the agreement, and this was followed the common law system. So whether you can use the electronic signature on those agreements, it depends on the situations. If you didn't obey some regulations, and this will turn into a contract. And there's no case in Hong Kong to confirm whether it can be signed electronically. So if it's an agreement, it's better to use the traditional signature, the handwritten one. But for example, the power of attorney and some statutory declarations or wills or some court documents, any court documents, are not allowed to use the electronic signature. Apart from the contracts, if there are some financial losses in the relevant parties or some disputes among different companies, and they will go to the litigation. And how to avoid this litigation risk. This is another type of a risk. First of all, it's better to have or formulate jurisdiction strategy. And we encourage to use the Hong Kong law because Hong Kong has a very relatively complete case law. It's very historical in terms of regulation. In a specific dispute resolution, arbitration or litigation, this is a very important consideration. And the privacy is one of the most important considerations. And if you know that the executive parties have different assets in different places in the world, arbitration is a better consideration. And if you are considered about the appeal, and perhaps the better choice is returning to the court. So you have to make the decision before going to the jurisdiction procedure. And many people said whether we will suggest a multi-layer dispute resolution mechanism, or perhaps go to the mediation first and then arbitration and the litigation afterwards. I think in the practice, it's unnecessary. And sometimes, as long as the relevant parties have this willingness, and they can do this, and it's not have any restrictions on the regulatory level. And sometimes, if you apply the multiple layer or multi-layer dispute resolution mechanism, it will postpone this procedure. And when you draft the contract, it must be carefully considered. Another risk is about the insolvency risk. And any party may face this kind of bankruptcy or insolvency risk. So first of all, we must have a clear term in the exit mechanism in the contracts. In addition, in the cross-border scenarios, there is a good mechanism between Hong Kong and the mainland to help each other. And in Shanghai, Shenzhen, and Xiamen, we have our pilot projects. For example, if a Hong Kong court assigned a liquidator, and he wants to go to mainland to collect the documents and assets documents and fulfill its responsibility as a liquidator. And Shanghai and Shenzhen and Xiamen have the correspondent institutes and to help this liquidator. Just follow some simple rules, and this will have a very easy procedure to do the liquidation. So other than those cities, and the people will go to the local court to do this submission and approval. So whether Hong Kong court will admit these liquidation from other cities, from the cities other than those cities I mentioned, and actually it's not. And in the common law, and we will also allow the liquidators of other provinces and cities and to do their survey and also the investigation and to fulfill its responsibility as liquidator. So those are the advantages of Hong Kong, and how does Hong Kong help the enterprises to go global in the cross-border disputes and mitigate the risks. And this concludes my sharing. Thank you. Thank you, Ms. Fan. And it's a better time controller. Very accurate. And Ms. Fan is very experienced in the cross-border litigation and also its relevant risks. And a lawyer is different from other professions. And if a lawyer tell you not to do something, it's not very common because lawyers like the risks and like the different lawsuits to happen. But in this forum, and we are very happy to listen Ms. Fan's advice because this is a professional forum. And next, we'd like to invite Ms. Winnie Tan, former chairman, the Hong Kong Bar Association, and a member committee on intellectual property of the Hong Kong Bar Association. And her topic is cross-border cooperation and protection of intellectual property. This is a very meaningful and significant to the development of the 15th five-year plan. Thank you. Thank you. The introduction of from Mingfeng. Good morning, everyone. And this morning, it's not about any announcement, and I don't have any PPT. I know that time will be continue to be compressed, and I'm not sure on how long I can talk. So I will just talk about several points. First of all, I'd like to talk about the IP litigation history. And in 1988, I'm already the professional barrister. You may be a little surprised. I'm in my 40th year of a professional career this year. And in 1988, I had just completed the intellectual property litigation training from UK and returned to Hong Kong. I was actually studying the master degree, and I didn't do the year-end exam, and then rushed back immediately to Hong Kong. Why? Because the first patent disputes in Hong Kong was about to happen. Why should I rush back? Because I was ordered to help in this lawsuit. And the relevant product is a hair remover. And this hair remover is a home-used appliance. It's a kind of a breakthrough invention back then. So big companies with large market share are challenged this invention from this company. So this is an Israel company versus Remington company. It's actually becomes a part of international patent litigation. And I was in London back then, and my master's I was fighting this lawsuit, and then he came to Hong Kong. Why he came to Hong Kong? And Hong Kong was a trapdoor back then, and the products was produced in Hong Kong, in mainland, and then re-exported through Hong Kong to the world. In 1980s, 1990s, and even the early stage of 2000, and Hong Kong had experience in this area because Hong Kong is a trapdoor, and many software were developed in Hong Kong, and we see the development of games as well as all kinds of softwares. There was very vigorous trade and exhibitions and happened in this building. And it's also related to many IP lawsuits, and our experience is accumulated from those years.
Ms. Zhou just now talked about their practices in Guangdong, in Shenzhen, how they grow their business. And now, what is in front of us is that in GBA, we see great demands for fundraising. We see great demands for businesses going global. In the last weekend, I had a chance to visit some of the high-tech companies. It's quite a surprise. Their technologies are amazing. And they will come to Hong Kong very soon for joint ventures, also for the purpose of fundraising. Ms. Fan talked about it earlier as well, that there are some risks in this regard, and we need to take measures to mitigate the risks. Shenzhen is regarded as a IPR center, which is called the Intellectual Property Right Protection Center. And this center is playing a very active role because during the R&D period, businesses need such protection service. And the center provides a one-stop services. So from the indexing of the patents to services needed during going global, the center can provide one-stop services to the local businesses. During this process, I think that Shenzhen Intellectual Property Right Protection Center has the capability to provide various services, including training services, so they can help the lawyers. And more importantly, they can help the local businesses in going global. The loop is another key topic nowadays because there will be a new high-tech corporation area because half the loop is in Hong Kong and the other half is in Shenzhen. So it will be even better for the two sides to communicate and cooperate. So in Hong Kong, in addition to the position as a financial center, Hong Kong has some other advantages. For example, its information flow capability. So in Hong Kong, information is also protected by law. I have to mention dispute resolution. So in the future, disputes were resolved through, for example, a commercial dispute would have to be resolved through arbitration. So usually it is for maritime affairs or construction matters. So usually for the litigation lawyers or commercial lawyers wouldn't have a lot of knowledge on arbitration or such dispute resolution. And now the commercial arbitration has already become a mainstream. The IPR is also a very technical sector because there are two types of IPR disputes. The other one is about infringement. So for the IPR infringement, you don't have a business relation with the patent holder. So you infringe, and the other party would sue you because there isn't any contract in place, no contract is signed. But whenever there is an infringement, and then lawsuit will be brought to court, and sometimes the parties just come to settle finally. So this is one type of IPR related arbitration. The other is about the IPR arbitration. So that is, you have already got the licensing or the permission, or you are business partners with each other. But in some joint ventures, such intellectual property right has become a very important part of the value of a business. For example, in Shenzhen is growing very, very fast. One of the sector that has been growing fast is the high-tech technology, high-tech companies. And the major part of the high-tech companies is on the IPRs. So therefore, in commercial arbitration in this regard, your capabilities are really critical. So these needs are high scales. 2 days ago, I had a chance to had a meeting with the vice president of WIPO in Hong Kong. So sometimes they don't understand. Hong Kong is such an important place in the world in terms of international property right organization. So why, for example, in mainland and in Singapore, why they they set up their own arbitration center? So why they don't have why still there isn't a lot of cases? I think it is because of that IPR organizations are not connected to the arbitration organizations sufficiently enough. So because between these two types of organizations, for the distributed resolution of international IPRs, so they are not playing their role as a key dispute resolution organization. So therefore, WIPO, even though it is a very important organization, however, not a lot of people would choose WIPO, and a lot of people have no idea what is WIPO is. And even for me myself, sometimes I'm not sure whether I am a arbitrator to WIPO or mediator to WIPO. I even asked him. So before I came, I wanted to know whether I am in the register. He said that he also had a look at the register, and you are in the register. It's only that they don't do any marketing. They don't publish the register of the arbitrators and mediators. That's why no party would go to WIPO actively to seek the arbitration services or to use the dispute resolution mechanism, because they don't know what mediator or arbitrator would be assigned to resolve this. So this is the kind of a disconnection. So please allow me to finish my sharing within 1 minute. So now we are all here to protect the IPR protection in the Greater Bay Area. Governments in Guangdong and in other cities, as well as their customs, have already been taking very active measures, and I wouldn't elaborate too much. But for the dispute resolution, either through arbitration or mediation, I don't think that we should focus too much on setting up a new arbitration organization, but rather by utilizing the existing organizations. And because of those organizations, they were established a long time ago. They have got a very good experience. To let them play the role and let them to help with resolving the disputes in the Greater Bay Area. Hong Kong International Arbitration Center was set up 50 years ago, and the Shenzhen Arbitration Center has also got a long history. They have got a lot of experience as well. So in addition to these two organizations, of course, there's CITEC and Shanghai Arbitration Center and so on and so forth. Beijing is also going to set up their own arbitration center. I think that instead of putting a lot of resources in setting up new organizations, why not just let the existing organizations play their role and hand their disputes to those organizations to handle? So I'm sorry I have stolen some time from Madam Fan, but no problem with you. Thank you very much. So when they mentioned a lot of organizations, and they are all here in Hong Kong. If you want to do arbitration on your intellectual property right, please come to Hong Kong, and this will also help Hong Kong to market ourselves. Sometimes I think I will ask Madam Tan in a minute. Actually, for IPO, just like IPO, intellectual property right can also be a trading platform. It can also be a market that can be sold and bought in the market. Hong Kong is a very good trading platform for intellectual property rights. And finally, I would like to invite Mr. Henry Yu, principal partner, to share with us. And Mr. Yu is from Elna Y Law Office and Henry Y and Associates. He is also a member of the Department for Justice's advisory group of Guangdong, Hong Kong, Macao, Greater Bay Area lawyers. He's going to talk about safeguarding property rights in emerging assets. Mr. Yu, please. So you're the last speaker. So stay well. Well, I thought that I was the last speaker. That's why I would have more time. Okay. Anyway, thank you. I am Harry Yu. It is my great pleasure to speak with you. I know that I'm standing between you and lunch. And some friends that they are still waiting for my presentation before they leave. Thank you very much for that. I hope I won't disappoint you. So I am a GBA lawyer. I'm one of the first batch of GBA lawyers. I want to be closer to you. I don't want to stand behind the podium. That's why I want to stand in front of you to get closer to you. I have been working in these years for 20 years, not yet 40 years, but I have been working in this industry for 20 years. I'm a Hong Kong lawyer, UK lawyer. I'm also a GBA lawyer. Before that, so I worked in the capital market, but in the past 10 years, I have been working in the virtual assets sector as well. So it is because that I had interest in this area. That's why I set up my own law firm. I have a limited time, so we can only focus on some of the key issues here. That is how to safeguard digital assets in Hong Kong and how can Hong Kong do. So first of all, the conclusion. Hong Kong has been the best performer in terms of safeguarding digital assets. Talking about digital assets, in terms of safeguarding digital assets, Hong Kong took initiatives in 2018 and started researching on this topic by SFC. In 2021-2022, the first batch of licenses for digital assets was issued, including also and HashKey. Altogether, we have got 11 licenses for digital assets, as well as the digital assets exchange. And there is still a long queue waiting for their licenses, and hoping this year and next year there will be more licenses. In 2023, 2024, there are some new policies, and in 2025, you may concern some of the hot topics such as the stablecoin. The other is algorithm A and also the OTC. Hong Kong, in 2025, Hong Kong issued the SP-RE, which is a comprehensive regulatory principles, and safeguard means S means safeguard. We have to make sure that with a safe pre-contest, that we are able to expand digital assets. SFC, on the 26th of June this year, also announced that some new rules and regulations. And SFC is going to supervise digital assets as well by optimizing the relevant laws and regulations in order to in line with international standards. On the 3rd of October this year, this is a new landscape, that is the DART. As mentioned yesterday, the Hong Kong MA, so T means in DART, T means tokenization. So tokenization and resilience are also focuses for us. Why there are so many risks regarding digital assets? In the past few years, some major happenings in the world had got attentions from many people. Still remember in May 2022, there was an incident which is Unilara. It is a unitary is a stable coin. And here from this chart, you can see in May 2022, their price, so just within one day, So from $1 to $0.35, even though it is called a stable coin, it wasn't stable at all. It is a failure. It is an example of a failure. So from $80 to zero, it just took several days.
At the same year, you may remember the FTX event. FTX was the second largest digital exchange, and also it was in Hong Kong, but they are not licensed in Hong Kong, and they finally returned to Singapore. Of course, they have a lot of Hong Kong employees, and they still have the office in Admiralty. And within 1 month, a few days, they changed from a normal enterprise to bankruptcy enterprise, and they have to apply for the bankruptcy protection from the United States. So you see, if there is no exchange to regulate these companies, it put everyone at risk. Another event is a JPEX. It's not regulated in Hong Kong or not operated in Hong Kong, but they leveraged the loopholes that we don't have any regulations of OTC. They use the KOL and OTC to promote their products in Hong Kong market. As we know, 2,500 investors were lost, and the loss is over 600 million Hong Kong dollars. It's very significant. But we are lucky that Hong Kong is very active in following this event and a case. And we know that 16 people were litigated by the Hong Kong police. And we also use the 15.3 ZRG to suit them, and they also use the red orders of the Interpol to trace their assets. Last but not least, I would like to mention about this Bybit event. It's about 1.5 billion US dollars loss. It's not occurred in Hong Kong, but you may know a lot of digital assets were in Hong Kong, and many platforms have been involved in this Bybit stolen digital assets. That's one of the reasons why Hong Kong police were so concerned about this. And how do we supervise those risks? Generally speaking, the SFC as well as the Hong Kong MA will be the regulatory bodies, and the license number 7 and the 1 will be this license to regulate this digital asset exchange, and of course the custom will become the other supervisory body, because many companies are related to the loans and data asset. So if new investors want to do this digital asset investment, they must comply with the due diligence and must fulfill the responsibility of a qualified investor. And in terms of the number 1 license, and they must go to the Hong Kong licensed exchange, including the OS hash key, and they don't need. It's not allowed to be exchanged in those non-registered place. And if you do the asset management, you must obtain the license number 9. If the total asset over 10% are related to the digital assets, they must apply the license from the SFC, and also will be regulated by the SFC. And the license number 9 has the similar regulation requirements. In addition, why the exchange platform is very safe, because because those platforms are subject to the VATP regulatory model. In general, our exchange, first of all, must separate their customers' digital assets, and 80%, 98% of them will be put in the cold wallets. And of course, they will have the asset insurance and compensation arrangement. So if you encounter the Bybit events, and we have the insurance scheme and the system in Hong Kong to protect you. In terms of the technology service, they also have these HSM and hardware safety modules, and to safeguard this. And for the key shareholders and the senior management, we also have a very high requirement. Stablecoin. And in August, we have the stablecoin regulation issued. And there are about 63 companies applying the license. And we hope that in the beginning of next year, some license will be introduced. We also have a rigid requirement on the on assets, 100% or above as an underlying assets to support this digital, this stable coin issuance. For example, if you have 100 million in circulation, the underlying assets must be at least 100 million or even more than 100 million. In addition, there also has an independent audit requirement, an independent public disclosure. And the redemption is also stricter, and stricter than the US and Singapore. And the redemption must be done within 1 day. Last but not least, I'd like to talk about the RWA, and it's related to the mainland market. Last year, many companies in mainland consulted me about the RWA. RWA, as we know, and people want to transfer some traditional assets to the chain and to become tokenized. And SFC in Hong Kong has already issued certain rules. For example, classification on different digital assets, including the non-traditional digital securities. So what are the tokenized securities? It includes tokenized bonds and tokenized funds. And we use wrapper. It's a tokenized process to do this. And in Hong Kong, we have a set of regulations to do the RWA. You may see the current regulations, existing rules, for example, disclosure of the prospectors and the public offering systems, and those are followed our traditional systems. And you may hear that the Ant and also other companies issued the RWA last year, whether some assets can be replicate. I think in Hong Kong, we have already got a set of rules and the package is good, but it also depends on your underlying assets. It depends on the quality of the assets, and as long as you got those good underlying assets, and you can use Hong Kong as a platform to go overseas and to raise funds. And this is about OTC platform. And the SFC will issue the license next year. So the JPEGs incidents will not occur again in Hong Kong. Last but not least, and the Hong Kong police also established this virtual assets information investigation task force, and they will targeting those kind of risks. And if you are interested in this regard, you are welcome to communicate with me after my presentation. Thank you, Henry. It seems you have a little overrun, and I have some foresight of the risks. Thank you all the panelists for your sharing. And the conference organizer and reserve 15 minutes for QA. Here's a question to Ms. Zhou. And Ms. Fan talked about the electronic signature and its legal force in Hong Kong. So, Ms. Zhou, could you share that the electronic signature situation in mainland, any limitations or restrictions or any disputes caused by the electronic signature? For example, the former U.S. President Joe Biden using the electronic signature, whether it's valid or invalid. What about the relevant laws in mainland? Okay. I thought the question was related to the capital market. My simple answer to this question is yes. The electronic signature and its legal provisions in mainland, and we have this legal provisions or any disputes from it. And as a CIA arbitrator, and encountered some cases. So if people do the corresponding transactions in mainland and using the electronic signature, you must pay more attention to the relevant laws in mainland China, including the prohibitive situation that cannot be triggered. And Judge Zhao is also here. So in our cases, we see more disputes about electronic signature. So the answer to the question is very obvious. Our legislation on this regard is still in the improvement process, and it should deserve the attention, more attention of the lawyers. Thank you. The next question is for lawyer Yu. With the current computing power largely increasing, what's the impact on cryptocurrencies? As you know, in Bitcoin or some underlying assets, it has about 51%, a so-called 15% computing power. If you can control the 51% of the computing power, so you can have the right to change the account. And worldwide, one company is very close to reach the 51% of the total computing power. Of course, when the computing power is ahead of others, and other people are also improving their computing power. So the 15% control of the computing power is difficult to realize. Secondly, why people pay a lot of attention to the computing power.
So for digital assets, the market size is over 1 trillion. So, spending so much efforts and resources to attack this 1 trillion market, so far it doesn't make sense, and the people don't think it is a big risk. Even though for this 51% attack in the prospectus or some other reports, you can see that such a risk must be disclosed. Okay, thank you, Henry. And next question, I also want to ask this question, Madam Tan, for intellectual property right. So how possible, how feasible do you think that Hong Kong can serve as a platform for intellectual protection, right protection? And what so do you think that we can have a common vision for this? So first of all, I'm not a trading expert. I'm not a trading lawyer. For the trading platform of intellectual property rights, for many years, the Hong Kong SR government asked me once and asked me for my opinions. Well, I think if you want to set up a trading platform, you must have products first. So products, they can be technologies. They may not be physical products that contains technologies. They can be technologies by themselves. The technologies can be packaged into a kind of a product. For example, so some diagnosis technology or some cell technology, so on and so forth. You put such technologies onto your platform. I think Hong Kong doesn't have enough talents. Hong Kong must set up must build up its capacity, particularly in terms of valuation. The valuation of IPRs, the valuation capability for technologies. In this regard, I think Singapore is doing very well because they have thought leadership organs who lead such developments. They have Singapore Academy of Law. In Singapore, they have IPCOS. They have the IPR reserves, and they have the different sectors contribution from the accounting sector, from the legal sector, scientists, scholars, so on and so forth. They developed and built and such a thought leadership. Some academic leadership on the IPR valuation. I think valuation really matters. You have a trading platform, and you have to consider about the valuation. So if the value is not evaluated in a fair and calculated, and then the trading platform will not be easy to set up. And so in a straightforward way, well, this is the direction for our efforts. But the value for the trading itself, for the technologies, the products, I think if the values are very straightforward, if the values are easy to evaluate, then there won't be any issues. But I think our effort should be spent more on the evaluation talents. Thank you. Ms. Fan, a question for you. If a client anticipates that there will be a cross-border litigation, what measures can a business to do in order to prepare for that? Thank you, William, for the question. So if litigation already happens, and then, well, you have to consider what you can do in the future. If the litigation is over, what will you do? What will you do in the future to prevent? So first of all, you think about what is the assets the other party has. Is there any assets there, and what measures you can take, and where to litigate. if things has already happened, first of all, you have to think about the litigation itself. You have to think it through where does the counterparty has its assets, and so that it is kind of the investigation of assets. Arbitration or mediation, evidence plays a critical role. So you have to collect all the evidences well. So if, for example, if there are some very important records which are not kept well, particularly when the dispute arises, and then very often the counterpart, you then you can accuse the party. So why don't you keep the records? Is it because that there's something information which is not in your favor in the records, so that you can make an accusation for that? So if it is you are the accused party, then you will be in trouble. So you have to keep all the evidence well. Of course, you have to consider, so between Hong Kong and the mainland, so for the IPR, so for the assets. So can we really freeze the assets? So according to my experience, to secure the assets, so we have different entry barriers in Hong Kong and in mainland. So you have to really take a look at your evidence if you want to secure the assets. So whether there's any risk involved, you have to investigate that. You have to prove that. It's not that they have assets and you sue the other party and you ask for security of assets. So it is very difficult. I think this is some of my ideas on this. Thank you. Thank you very much. Next one, Mr. Ms. Chen, you promoted Hong Kong. Hong Kong did a good job in IPO. The question for you is that in terms of fundraising in the capital market in Hong Kong, in addition to the channel for IPO, is there any other product or channel that can also help the businesses with fundraising? Thank you. Thank you, William, for the question. Right. In the capital market in Hong Kong, in addition to getting listed, and you have stocks, you have the bonds as well, you have other channels. So for the OSR and the other is HK, these two virtual assets exchanges, I took a look at the prospectus. There are both platforms or exchanges for virtual assets. They are listed, but what is underlying is that so it's not a manufacturing because it is a virtual asset, and in the capital market, you actually can move to upper level as well. Some other products we have. So we have, for example, connectivity products, Well Connect product, and the Bond Connect product. So in the past few years, between Hong Kong and the Greater Bay Area, we have such connectivity. So that's why we have launched the different products. And this actually can show that in the Greater Bay Area, in addition to stock, we have other products that can be issued in Hong Kong as well. Thank you. Then finally, a question. So please spend 1 minute and share with you your thoughts. So for the lawyers from 3 regions, there are differences between them. How can we work together to help business in mainland to go global and deploy globally? So Ms. Chen first. So this is a very good question. For us, I work in the Chinese firm. Before that, I worked in a foreign firm. I have felt deeply that we, in cooperating with different lawyers from different regions, particularly from Hong Kong, we have a different way of thinking. Sometimes we found that the communication between mainland lawyers with the businesses, with the clients are very smooth, and sometimes they know how to put themselves in the shoes of the clients. And for trained lawyers, so we are very technical. We know the products and we know the laws and regulations, all the articles well. But in the real practice, so do you know the products? Do you know how to communicate with your clients? I think in terms of lawyers from mainland and from Hong Kong, I think that we must learn from each other and improve together to do a better job together in the future. Okay, Ms. Zhao, Actually, you made a very important point. So the key word is a difference. So difference actually is the major feature we have and also the value we have in common. So it's exactly because of the differences we have. That's why we have to cooperate with each other. Without a difference, you don't need to cooperate with each other. So in this regard, I think that we have to understand what is the difference, and I think what advantages we have. You know, we are close to assets, in Guangdong. So because a lot of businesses in Guangdong, they are also going global. They are in mainland, they are in Greater Bay Area, they are in Guangdong. So we're closer to the assets. We know what they need and wants. Some Hong Kong and Macao lawyers, they are close to capital. They are close to international capital. The Hong Kong is a platform for fundraising, as you said. So I have been promoting Hong Kong included and promoting cities in the Greater Bay Area, Hong Kong, Shenzhen, and Guangzhou. So the second feature we lawyers have is that in addition to being close to assets, we know what the challenges are and what are the objectives, missions, strategy, planning when a local business is going global. So one advantage we have is that we can use the language that is understandable to the local businesses to do. So the Guangdong lawyers are the bridge. So we can work together with the Hong Kong and Macau lawyers to provide services together as a team to the local businesses. This is the best team, the best combination. I think this is also the shining point of our cooperation. That's why I'm very confident. Okay, thank you. Ms. Fan? Okay, thank you. I think so. There's no better opportunity than today to talk about this, as we have hundreds of people gathering here together, organized by DOJ. Personally, I think in my career and in our discussions today, I think it is really good that we sit down and discuss face to face. Recently, we have been helping with a Chinese investor in Holland, and something happened recently. The Hong Kong lawyers, UK lawyers, the Netherlands lawyers work together. We have had a lot of online meetings, and finally we set up a team. The lawyers from four regions. We spent 2 days having a meeting, talk to each other face to face. So I really appreciate it for such an opportunity organized by DOJ to have such a face to face discussion. Thank you. And Madam Tan, I do agree to all the speakers said earlier. Very important, all of them. So I just want to make a quick point. So we want to cooperate with each other, but cooperate with whom? Let me try to give you an answer. You have to understand what strength you have, what strength the other parties have. We are professionals. We are professional lawyers. We are not competitive to each other. Do not lower yourself. To find the right partner with the right strength to cooperate with. We are strong in different areas. We have a different strength. Our responsibilities to our clients to find the right partner to deliver the best service. So you must have the partner with the right experience to have the right strength. Okay, thank you. I do agree. So 1 minute. So Madam Zhou said that we must take care of the differences carefully. So in one country, two system, I think this is also a good reflection of the one country, two system. So from 2018 to 2020, I was kind of a confusion, because a lot of businesses went to Singapore. Still remember, so in 2017, 2018, the domestic laws, there were some changes. At that time, no matter what I told them, that in the long run, so maybe their digital assets will also be constrained in Hong Kong. But actually, that is the worry from others. And SFC has been working hard to promote digital assets in Hong Kong. I actually verified with them several times. I think Hong Kong is a pilot, and we have the capital pool, lawyers from mainland. They are close to assets. So in this market, we can work together and do better. Okay, it's 12:45. Thank you very much. Thank you all. Thank you. So please stay seated, and we're going to take a group photo.
我们今天主
Thank you, the moderators and all the panelists, Ms. Chen, Ms. Zhou, Ms. Fan, and also Ms. Tan and Mr. Yu. Thank you very much. One more photo, and we also need to take some videos. Thank you very much. Please be seated. Thank you, your excellent sharings. Please be seated. Thank you. Distinguished guests, ladies and gentlemen, thank you very much for attending Hong Kong Legal Week 2025 Day 5, the morning session. The first GBA Lawyer Forum has successfully concluded. On behalf of DOJ, I would like to sincerely thank all speakers and the moderators for your insightful and wonderful sharing. And also especially thank every guest who participated in today's forum, both in person and online. And you can fill the feedback form by scanning the QR code. Online participants can fill it online. Thank you very much. Guests who participated in person and need to apply the CPD or the ALE credits, and you can show the QR code outside for departure registration to confirm your attendance. Guests invited to the luncheon, please proceed to the restaurant guided by our staff. And we are also sincerely inviting you to visit our exhibition of S227 to 227. 226, and this is about legal technology exhibition, showcasing the latest innovative products and technology. And I welcome you to learn more about information on legal technology. And thank you again for your participation, and I wish you all a good health and success in your work. Thank you.
Welcome to LawTech Guess Who. Today we'll have two teams of participants, the algorithm Avengers, who perform our legal tasks with AI tool, and paper pioneers, who will utilize the traditional method in completing legal tasks. Let's get started by having our law storing sessions.
In this case, the defendant claims that the shove was to keep distance after Zheng advanced aggressively, and the block was to protect his sister from perceived harm. Zheng initiated physical blows thereafter. If in the car videos corroborate Zheng's aggression and defendant's defensive posture, this will strengthen the self-defense claim, and the proportionality test will be the key. A shove and block can be reasonable responses to an advancing aggressive person.
In our view, there are some weaknesses for the prosecution's case. First, there's no direct witness to initial altercation. And second, the medical evidence undermines causation. It points to the complications died from the epilepsy, but not some injuries from the assault itself. Third, the defendant's acts might constitute self-defense. They were plausible and proportionate and was not disproved by the prosecution beyond reasonable doubt. And fourth, the video may support defensive conduct, and we are of the view that the defendants will likely be acquitted of this offense.
As an overview, the admitted facts only shows there is an assault. It fails to show any assault between the parties. And the medical report adduced as an evidence only shows to the extent that the cause of death, also the timing of death by the deceased, but it could not show any harm of actual body harm caused by the defendant. Further, the two witnesses called by the prosecutions does not support the elements. First, it is not eyewitnesses. Second, it only shows the event after the deceased has been collapsed.
Now, applying it to the facts of the case, and according to the defendant's evidence, we say that the two occasions in which the deceased was inflicted force by the defendant were actually due to provocation or the use of force from the deceased, meaning self-defense. In the facts, we see that when the deceased suddenly advanced and caused his chest to collide with the defendant only shoved the deceased to maintain distance. Assuming this is believed by the court, this is obviously a proportionate reaction to this. Secondly, when the deceased tried to strike the defendant's head with his fist, the defendant only raised his arm to shield himself. So judging from these facts and from what we have said, we are of the view that the defendant will be acquitted.
check.
Hello, testing. 1, 2, 1, 2, 1, 2. Ladies and gentlemen, can you hear me okay? Perfect. Thank you.
Testing.
Good afternoon, everyone. Dinner is served. Okay, no, thank you.
Can't follow that. All right, that'll be fine. I think it's at the right place.
Hello. So you guys would like to have two handheld mics,
Oh,
right?
just in case.
So I will just put it here.
Okay.
And then
okay, that's fine.
maybe here.
Yeah.
So you guys feel free to.
I feel like TVB style now.
Oh, like TV hosts. As well. Sell it to my mama. Testing.
Dear honorable guests, ladies and gentlemen, good afternoon. This afternoon session will start in about 5 minutes. Please be seated and switch your electronic devices, including mobile phones, to silent mode. Thank you very much for your attention. Please note, simultaneous interpretation is available in Putonghua and Cantonese. For those who are with us here at the HKCEC, headsets are available at the entrance of the hall. And if you are participating online, you can choose the preferred language channel on the Hong Kong Legal Week website. For in-person participants who require continuing professional development, CPT credits, or advanced legal education, ALE credits, please make sure to present your QR code outside the conference hall and check in and check out before leaving for today. On the screen, you will also find the QR code to access today's program and evaluation form. We hope you can share your feedback with us after the event. Thank you very much. Ladies and gentlemen, please be kindly reminded we will begin shortly. Can I please invite everyone to please take a seat? Thank you very much. In the meantime, please also double check your electronic devices to make sure they are on silent or vibrate. Thank you very much. Good afternoon and welcome back. Distinguished guests, ladies and gentlemen. Last week, a fire broke out in Hong Kong, causing catastrophic damage and the tragic loss of many lives and homes. We are deeply saddened by this incident. The government of the Hong Kong Special Administrative Region and the Department of Justice express their profound condolences to those who lost their lives and those who loved their lost ones, and their deepest sympathies to those that are injured, and also the affected families. May I please invite all of our guests and everyone present to stand up and observe 1 minute of silence with me. Thank you. Everyone, please be seated. Also, a kind reminder, during this event, which is about to begin, may I also invite all of our participants to refrain from applause as a gesture of respect and mourning. Thank you very much for everyone's attention. And welcome to the session, The AI Era, Shaping the Legal Landscape in the 21st Century. Now, it is our privilege to have all of us with you and all of you with us today. Now, without further ado, can I please invite Dr. the Honorable Chen Kuo-kwan, SBS JP, Deputy Secretary for Justice, the Government of the Hong Kong Special Administrative Region of the People's Republic of China, for a welcome note. Dr. Chen.
The Honorable Mr. Justice Locke, distinguished guests, ladies and gentlemen, good afternoon. Welcome to the main stage LawTech Conference today. It's appreciated that so many of you have chosen to join us today despite the difficult circumstances in our community, and stand ready to engage thoughtfully with the challenges and the opportunities of the LawTech and artificial intelligence bring to the legal profession. The inaugural Hong Kong LawTech Fest 2025 helps to bring together legal practitioners, technology providers, experts, academics, and policy makers to explore the fast-evolving intersection of law and AI, and to showcase the latest innovative products and services shaping legal practices. The LawTech Fest features a dynamic brand of exhibitions, live demonstrations, and consultations, and expert dialogues. As Hong Kong embraces the transformative AI era, with the LawTech and AI reshaping the delivery of legal services, we hope that the LawTech Fest would provide a platform for attendees to discover cutting-edge solutions, stay ahead of trends, expand professional network, and gain actionable insights to advance innovation in their own legal practice. The theme of today's conference, the AI era, shaping the legal landscape in the 21st century, sits at the heart of an important dialogue about the future of our legal system. LawTech and AI are transforming legal practice, enhancing efficiency, accessibility, and quality in delivering legal services. By automating routine tasks such as legal research, document drafting, and review, these technologies allow legal professionals to focus on high-value activities, such as strategy decision-making and client relationship management. Moreover, LawTech and AI solutions enable more effective data management and analysis, facilitate informed decision-making, and predictive insight. This technological integration also improves access to legal resources, enabling individuals and business to obtain quality legal support more easily and affordably. As we navigate through the increasingly complex legal and regulatory landscape, it's vital that we address these frequently asked questions. How can we integrate AI professionally and responsibly into our legal practice? What are the risks and ethical implications that we must consider? And most importantly, how can we ensure that technology can act as a complement to human touch, which remains pivotal in the practice of law? Today's conference timely examines the opportunities and risks associated with AI's growing role in the legal practice. The DOJ is steadfast in its commitment to foster innovation and the integration of technology in the legal industry. To promote the development of LawTech, we established the Consultation Group on LawTech Development in January this year and invited the industry and various stakeholders to jointly study and formulate policy measures related to LawTech. This year, we launched the LexGoTech Roundtable Series and successfully organized 3 roundtables. Through the roundtables, we have gathered solicitors, barristers, arbitrators, legal educators, in-house counsel, and government lawyers, a diverse group of professionals who are vital pillars of Hong Kong's legal services delivery, to exchange views and experience on opportunities and challenges that LawTech and AI present to the legal profession in Hong Kong. Today, I would like to announce the release of the LexGoTech Roundtable report. The report summarizes the insights gained from the Roundtable series. More details will be discussed in the 2025 final round of Roundtable series taking place here on this stage later this afternoon. Additionally, the DOJ launched this survey for LawTech service providers in Hong Kong in October. We are now analyzing the valuable feedback which we believe will significantly shape the future steps in our LawTech AI development strategies. Going back to today's program, we are very honored to have the Honorable Mr. Justice Locke to deliver a keynote speech on LawTech and the future of law and justice. Following that, we will have an interactive LawTech Guess Who game, during which we will explore the advantages of using AI in legal practice while highlighting the importance of human input and oversight. Next, we will have the LexGoTech Roundtable Series 2025 Final One, during which we shall share key findings gathered from our earlier roundtables. On the basis of these findings, seasoned practitioners will exchange insights on the opportunities and challenges we face as we integrate technology into legal practice. I look forward to hearing our distinguished speakers' insightful sharing. Ladies and gentlemen, as we navigate through the AI era, we should bear in mind that our ultimate goal is not just to adopt technology for the sake of progress, but to harness its power in ways that uphold the principle of justice, fairness, and integrity. Technology is a powerful tool, but it cannot replace human qualities such as empathy, judgment, and integrity, which remains essential in legal practice. Only with an open and responsible mindset will we be able to grasp the opportunities brought by the LawTech and AI and transform the challenges into benefits. On this note, I wish to extend my sincere gratitude to all speakers, participants, consultation group members, and colleagues who have worked tirelessly to make this meaningful event and DOJ LawTech initiative possible. I wish you all a fruitful and inspiring discussion today. Thank you.
Thank you, Dr. Zhang, for the remarks. And please be seated. Thank you. Following the welcome note by Dr. Zhang, we would now like to invite the Honorable Mr. Justice David Locke to share with us his insights on LawTech and the future of law and justice. Mr. Justice Locke, please.
Deputy Secretary for Justice, ladies and gentlemen, I think the past week has been a difficult time for all the people in Hong Kong. I think our hearts are with all the people who died and injured in the devastating fire in Tai Po, and for those who have lost their loved ones and homes during the fire. We just hope that our beloved city will soon recover from this tragic incident. Now back to the talk today, I must say that when I first received the invitation to speak today, I have some reservation. As you would probably know, the LexGo general election will be held this Sunday. As the chairman of the Electoral Affairs Commission, I think I should be extremely busy this week, and I wonder whether I have the time to prepare and speak today. However, my hesitation lasted for only a few seconds, and I accepted the invitation. I think the reason is simple. This is a topic I have studied in the last few years, and I really want to speak on the subject. So here I am today, and I'm certainly more comfortable here in speaking on some legal issue as a judge. Now, today's topic is LawTech and the future of law and justice. It is a broad topic. There's a lot of things I want to speak today. And when I practice, look at my notes, I think I would certainly exceed the time allowed for my speech. So I try to put everything here into my PowerPoint presentation. So in case I have to rush through some of the things, then at least you will try to grab hold of some of the things that I want to speak today. I think today's topic is LawTech and the future of law and justice. But if you expect me to speak on how to use AI to give a legal opinion or to write a judgment, then I'm afraid that you'll be disappointed. I think you would certainly have more experience than myself in these regards, as judges would have to give judgment on the specific facts of the case to decide whether to believe a certain witnesses rather than give some general legal opinion. And further, unless we are in a secure and confidential setting, judges are quite reluctant to input sensitive and confidential information in the prompt for the AI program in order to assist them to write judgment. Well, I understand that there is a session later this afternoon on this particular topic. So I think what I'm going to speak today is something you would not welcome. I'm not saying on what the AI can do for us. I am saying what the AI should not do. Now, the focus these days is always what the AI can do for us. There's little discussion on the laws relating to AI and the implications and legal issues that would arise on the development of the new technology. So what I propose to do in the limited time today is to take stock of what happened around the world about the laws relating to new technology, and to share with you some of the implications and legal issues involved. I will try to address these issues from the Hong Kong's perspective and how we should proceed in view of these challenges. Now first, artificial intelligence. I think any forum of this sort would be incomplete without mentioning AI. Now, in the legal week last year, I have identified 5 areas relating to AI which deserve serious consideration in the future. The first one, as you see, is how to govern AI to make it more accountable and transparent. The second is the need to avoid bias and prejudice in the AI decision process. The third is, of course, everywhere all of us are aware of the privacy and the confidentiality issues. Now, 4 is very important, product liability. If we use an AI program to make certain medical diagnosis, what happens if the diagnosis turns out to be wrong? Who should be liable? And then finally is all the IP issues relating to the use of AI. Now, I do not propose to address any of these issues in great detail today, but perhaps I can give you an update about the legislative process now in different parts of the world dealing with these issues. Now, European Union, EU, is definitely the first jurisdiction which has adopted a comprehensive law on AI. That is the Artificial Intelligence Act. It was formally adopted by the European Parliament in March 2024, though the law is still going through the process of formal enactment. Now, basically, the law classified AI system into 4 categories, and then different categories would have different kind of regulations. Now, the first one is unacceptable risk. So for this kind of AI system, they would simply ban this AI system because of the unacceptable risk concern. So this would be about, for example, social scoring by the government or real-time remote biometric identification in public places. There would be some narrow exception for example, crime investigations. But apart from that, unacceptable risk AI systems are banned. So the second category is high risk. Now this would cover systems relating to critical infrastructure and medical devices. So for these kind of systems, it would be subject to strict requirements, such as requirement of high quality data and risk management. So the third category is AI system with a limited risk. So these systems will be subject to transparency requirement. That is, you have to inform the users that they are actually interacting with an AI systems. So this would be the third categories. And finally is the risk system, AI system with a minimal risk, such as AI-powered video games or spams filter. So there would be no obligations and no restriction for these systems. The law we are waiting to see whether EU would become legislation would have the Brussels effect. That means after it was enacted, eventually it becomes the de facto global standard. On the other hand, there are some other countries, Brazil, are also in the very final stage of the legislating process, adopting the EU model. The approach of the Chinese mainland is to enact, rather than a comprehensive set of regulations, they try to enact targeted and domain-specific regulations, imposing strict data labeling and security requirements. The law also aims to regulate recommendation algorithms, such as 大众点评, and all these programs which have a great impact on the social behavior, protect users and prevent addictive behavior. Now, US, the legislative process is more uncertain. In October 2023, the Biden administration has issued the executive order on the safe, secure, and trustworthy development and the use of AI. The order mandates actions to create new safety and security standards, protect privacy, advance equity, and to protect consumer. If you remember that addressed 4 of the areas I mentioned in my speech last year. However, it does not have the force of law, but only serve as directives. There were some bills now being discussed in the Congress, but the Trump administration has given a clear indication that AI should not be regulated. I think the fear is that they were afraid any kind of AI regulation would hinder or even stifle the development of AI. The UK has adopted a non-statutory approach. Instead of enacting specific AI laws, they rely on existing regulators, such as health and financial authorities. Now, health and financial authorities are usually the 2 main areas which there's a use of AI is very substantial and will have serious consequences. So health and financial authorities, they rely on them to apply core principles like fairness, accountability, and governance within their domains. So the same approach was more or less adopted in Japan and Singapore, and there are attempts to enact AI laws in Canada and South Korea. Now, while there is some development in the legislative process around the world to deal with the first 4 areas I have mentioned in the Legal Week last year, there has been no or even little progress in the legislative process to deal with the IP issues relating to the use of AI. So these are the 3 main questions that would usually, when I read through the literature, these are the 3 main issues or questions that academics would usually raise in relation to the IP issues. Now, I think each of these issues deserve a seminar on its own to cover the different implications involved. But I would try to here, within a very short period of time, try to give you a summary about the developments relating to these 3 questions. Now, the first question is whether AI program attract any kind of IP protection. So the question is whether AI is patentable. Now, I think it's been long established that mathematical method and computer program are not patentable. But however, there are many gray areas involved. In the limited time today, I do not want to bother you with all the gray areas. But interestingly, there are not many litigation around the world on this question, on the patentability of the AI program. I think the main reason, as I see it, is that if you want to obtain a patent, you have to disclose the inventions. So facing the uncertainty involved in litigation, it seems that most of the AI developers do not want to risk disclosing the technology or the algorithms behind the program. They just want to keep these information confidential. So if necessary, they may seek to protect algorithms as trade secret or confidential information. Now, the second question is, if you use, of course you know how to train AI. You need to feed a lot of data in order to teach the AI to do certain things and to recognize certain things. So, and a lot of the material used to train the AI are copyright materials. So whether the use of these copyright materials to train AIs amount to copyright infringement. Now this question, again, there are different approaches to deal with these issues. There are some countries which have enacted specific laws on what we call data mining exemptions. That means if I just exempt you, this would not amount to breach of copyright. For example, in Japan, it allows the use of copyright materials if the use is not for enjoying the thoughts or sentiments expressed in the original work. Well, the meaning are by no means clear. If you go to court, I think there can be a lot of arguments about what that means. Now, in the UK, it is permissible to make a copy of a work for computational analysis, but for the sole purpose of research for a non-commercial purpose. Now, this is a very important restriction. The UK government has published a consultation paper proposing to extend the data mining exception to commercial use. But however, facing strong oppositions from the Copyright Owners Association, there has been no progress in this regard. In the EU, they allow for use of materials for scientific research, but for any other purpose, for example, commercial use, they would allow you to use the copyright materials to train the AI, but subject to a right of opt-out. That means the copyright owners can reserve the right, I don't want my materials to be used for AI training. So the copyright owner can reserve their rights. So some other countries rely on the more principles, general principle of fair use. Whether the training of the AI amount to fair use, the notable example is USA, and however, as you can imagine, it creates a lot of uncertainty in the court, leading to some development of some concepts, such as making immediate copies for transformative purposes are allowed. So these are all principles developed by the law trying to cope with this problem, but the uncertainty remains. Now, there are many litigation around the world involving this question. Now, this is one of the topics I don't want to go through the case law. US, there's a lot of case law as to what amount to fair use. In the very recent decisions, Getty Images and Stability AI in the UK, this is a long-awaited judgment. They want to see how the court approach these issues. But this case, I don't want you to bother you with the facts, but the result is that this case highlights the problems faced by many copyright owners in making claims of. The plaintiff, in this case, sued the AI developer for the use of the copyright materials used to train AI. And the copyright claim, the plaintiff has to drop the main claim, primary copyright infringement claim, simply because the training took place outside UK. So if you move your server or training outside UK, then the AI developer can escape liabilities. So this case highlights many of the problems faced by copyright owners in trying to sue the AI developers. In these, you have to identify I think this, I try to skip through in view of the time. Now, while there's some legislative attempts to answer the second question, that is whether the use of the AI materials to amount to copyright infringement, you have the data mining exception, but there has been no attempt, as I see it, or very little attempts by the legislature all around the world to answer the third question. The third question is whether invention, music, films, photographs, or artistic work created by AI program can attract any IP protection. And if the answer is yes, who should be the one that enjoy the protection? The AI user, the AI developer, or whether it should be the AI as a machine that should enjoy such right. Now, as there are no codified law to answer the third question, the courts have to provide the answers by applying outdated laws. Now, these matters have been litigated in many places around the world. So far, there's only certainty in one matter. According to these authorities, AI cannot be an inventor or an author, which can be regarded as the owner of the IP rights. So obviously, if the AI as a machine, if you think about the implication, enjoys such rights, it would create more problems which would touch on moral and sociological issues. I think the matter should be properly debated in the legislature or the public arena, and I do not think that the court would go so far by saying AI itself as a machine has certain personality or legal status that can be regarded as an owner of the IP rights. Now, academics around the world think that UK is the only jurisdiction which provides an answer, at least so far as the question of copyright is concerned. They rely on the notion of computer-generated work, which is also provided for in Section 11.1 of our Copyright Ordinance. Now, the section said, for literary, dramatic, musical, and artistic work, the copyright of computer-generated work, that includes AI, right? Now, AI is computer-generated work. The copyright of the computer-generated work belongs to the person who arranges the creation of the work. So who are the one? You, the AI user, right? You are the one who arranges, input the prompt. So, but however, does it provide an answer? Now this is, to me, this is really much an outdated provisions, which was introduced before the technological advancement brought about by AI. Now, if you use a word program or in software to help you to write an essay or to help you to write, prepare drawings for design work, for architectural work, then I can understand why the user should own the copyright of the final work. After all, the input by the users will be substantial, and the law should perhaps protect the creative work of the users. But now we come to a stage when AI can create a piece of work without any creativity contributed by a user. The user can input a simple prompt, such as create a song with a romantic tone in the evening setting, or create a design or image with some simple parameters. In such case, should the user own the copyright of the final AI-generated works? Or should there be copyright protection in the first place? Or should there be copyright, or should the copyright be owned by someone else, such as the AI developers? Now, I have studied with some interest the views expressed by different academics about such issues. One school of thought thinks that there should be copyright protection because they believe that the granting of such rights would provide incentive for the development and use of AI. Another school of thought is that there should be no protection for such work, in particular for the users of the AI program. Now, using a simple experiment, if you provide a same parameters, same input to an AI program, the work generated today and the work generated tomorrow may be different, right? Now, so in such case, how can you say in such case there's any human creativity at all? Now, if there's any creativity involved, it certainly does not come from the users. Bear in mind, copyright is there, law is there to provide creativities, reward for creativities. So, I mean, these are all questions, unfortunately, the law has not dealt with, and as a result, it have to be decided by the court. Now, if you grant copyright to the AI developer, it also does a lot of other consequences, and does not make a lot of sense. So unfortunately, all these unanswered questions would have to be solved by the courts using outdated legislation. Common law judges are not expected to carry out researches or investigation themselves. So as a result, judges who know very little about AI world can make some unwise decision which has serious consequences. So such kind of matters should be resolved in the public arena with proper consultation with the stakeholders. Now, if you think about this, all these IP issues are in fact interrelated. Now, if you grant copyright to protect AI-generated work, how about the right of the owner of the copyright materials or copyright owners? Their materials are being used to train the AI. Should they get a share of the profit generated from the copyright work of the AI work. So in my view, all these questions cannot be considered in isolation. Now come to the conclusion. I think we have to acknowledge that legislating the law relating to AI is not easy. I think the first problem is that we do not know, because the technology is developing so fast, we simply do not know what the AI can do in the future and what legal and social implications brought about by technology. It is simply impossible for one particular group of professionals, say lawyers, to understand all the issues or implications arising from a particular piece of legislation. So a roundtable approach is therefore a must. And I'm glad that the DOJ is also taking a lead in trying to approach this issue with a roundtable approach. I think the second question is, of course, enforcement issues. Even if one has a comprehensive law on AI, the AI developer can easily avoid liability by moving the server elsewhere. Further, for example, if you say there should be a law to say that there should be a watermark in AI-generated work to indicate this is an AI work. But I think with the modern editing tools today, I think it would be very simply to remove such watermark, right? So there are a lot of enforcement issues. And in fact, people are now criticizing the EU Artificial Intelligence Act on the ground that because there are numerous enforcement issues. So in fact, in the end, all these broad principles, how do you apply or enforce it in practice? So enforcement issues, and certainly this would be a problem if you have to legislate on AI. The third is with geopolitical competition for being the leader in AI technology, any kind of regulations would not be an attractive solution. If you want to develop AI, coupled with the fact that any regulation in one jurisdiction may affect the whole AI system. Eventually, AI developers will simply move their research and operation to the jurisdiction which have the least regulations. So the best solution is therefore for countries around the world to harmonize their law. I think it would be very difficult to do so in view of the present geopolitical climate. I think the last issues, I'm running out of time, I'm aware of the time, is that a lot of these issues involve powerful stakeholders. So that makes the legislating process much more difficult. So facing all these problems, while a lot of governments see the need for some regulations, but some regulating legislation, they decided to adopt a wait-and-see attitude after the consultation process. Unfortunately, any dispute would then have to be decided by the court, which are wholly unsatisfactory. I just read the news yesterday that there was someone in organization in India relying on a certain provision in the Indian constitution, suing the government for failing to regulate AI-generated products. But the law, the court say, I think that would involve a lot of discussion on that constitution provisions, but the court dismissed the claim on the ground that the government has already issued a consultation paper. So we can see the difficulties in legislating in these kind of process. So facing with these difficulties, what is the path for Hong Kong? In my view, it would be too aggressive for a small jurisdiction like Hong Kong to enact a comprehensive set of law to regulate all aspects of AI operation. It would be necessary to study the operation of the EU AI Act before deciding the path ahead. But in the meantime, I think there's a few things that we can do at the moment. I think the first thing I suggest, a high-level roundtable conference be held so that all the stakeholders can put their views together as to what kind of regulation is required. Second, the administration should set up some good practices or broad principles for AI developers. For example, the need to avoid bias or prejudice in the AI decision-making process. And third, the administration can pick up a few areas enact specific and targeted law with a view to resolve some of the issues relating to the use of AI. I think another 3 minutes, shall we? I'll try to conclude. I think one of the areas I want to say is targeted area is the protection of personality rights. Now, I think with a view to protect improper use of images or recording. Now, I think you all know about deep fake, right? Impersonation technology. So using your technology, your image, voice print, to create something completely different. Now, if that act involves criminal conduct, for example, if you use a film trying to to deceive people into investing, this involves criminal conduct. You can try to protect by way of criminal law. But how about if there's no criminal conduct involved? Can I just use your image or photographs and make fun of you and use another photograph trying to put together, create something very different? Or use your raw print to say something which is, perhaps if you're a politician, to saying something which is against your ideas. So all these questions, I don't think, in view of the time, now there's common law, you have some limited ways. You can have tracing off, you can have privacy law, you can have defamation, and you can have IP protection. I can tell you all these would have limitations. I think in 1999, the Law Reform Commission has published a consultation paper on the civil liability for invasion of privacy, and there's a special chapter dealing with the right of commercial exploitation of personality. But I can say you this consultation is outdated in view of the present technology that can be achieved by AI. So in the mainland, I think I have codified laws to protect personality rights, to prevent improper use of one image, photographs or voice print. When I attended the Forum for IP Judges, organized by the World Intellectual Property Organization in Geneva in October this year, the presentation by the mainland judge coming from on this particular topic has actually arose a lot of interest from the audience. In particular, the judges coming from the common law jurisdictions, which do not have specific laws on personality rights. So the introduction of such law, of course, is not without controversy, and yet the Hong Kong government should perhaps revisit such an issue in view of the development of AI in recent years. Conclusion. Despite the difficulties involved, Hong Kong should stay ahead of all these issues. The WIPO, the World Intellectual Property Organization, has ranked Shenzhen, Hong Kong, Guangdong, first in the 2025 Global Innovation Index of the World Top 100 Innovation Clusters. As a member of this cluster, Hong Kong can serve some function which may not be able to perform by other partners. Hong Kong is always a superconductor between the East and West, between the mainland and other countries, in particular the Belt and Road countries, and between the common law and the civil law system. Hong Kong should therefore take a lead in the study of these tech-related issues. Study centers can be established, international multidisciplinary conferences can be organized to promote exchange of views. Promoting awareness of these issues may also give the tech people some more thoughts when they develop the relevant technology. While the path for the regulation of AI is a difficult one, there is no excuse for us to adopt a passive or wait-and-see attitude. I hope the contents of my presentation today will plant the seeds for further exploration into this uncharted area of the law. There are also another topic I want to speak is the standard essential patent litigation. Unfortunately, I don't have the time. But finally, also may I make a personal appeal to all of you here, who are voters here, to come forward this Sunday and to vote, and to try to help us to build a better and safe Hong Kong. Thank you very much.
Thank you, Mr. Justice Locke. Thank you for that. And can I please invite you to be seated? Thank you. Ladies and gentlemen, we now come to the LawTech Guess Who, an engaging and interactive game in exploring the benefits of LawTech in legal practice and the critical role of human lawyers in the AI era that we live in. Now, all of you will have the chance to participate in guessing which of the two teams, one using AI and one not, will tackle their legal tasks successfully. The moderators will introduce the game in more details later, and we would also like to take this opportunity to extend a special thank you to 3 AI tool service providers. Now, that is namely DocPro, Intelligence, and LexisNexis, which have generously offered some of the free trials for the participants to use in the game for today. Now, today we have invited 2 members from the Department of Justice Consultation Group on LawTech Development, Mr. Jonathan Vu and Ms. Stephanie Xu is our moderators of this session. Now, both Mr. Vu and Ms. Xu possess extensive professional knowledge and experience as well as insights on LawTech that will enrich our discussions in today's session. Now, can I please have the 2 of you join me on stage? Mr. Vu, Ms. Xu, please. Exciting segment coming up. And I will hand this over to the 2 of you without further ado. Thank you.
Good afternoon, everyone. Welcome to the LawTech Guess Who. I'm Jonathan, and I would like to introduce my co-moderator, Stephanie. We are here today as Department of Justice Consultation Group on LawTech Development, and we look forward to sharing our insights and facilitating an engaging discussion. Today, we'll examine the role of AI and LawTech in legal practice, exploring how AI transforms legal practice in terms of speed, accuracy, and engaging and strategy. The objective of today's event is threefold. Firstly, to showcase the advantages of LawTech in legal practice. Secondly, to emphasize the indispensable role of human lawyers retained in this AI era. And thirdly, to highlight the idea that AI and humans should complement rather than compete with each other.
LawTech Guess Who is an interactive and engaging game. So this game will involve 2 teams of lawyers who would be asked to perform 2 legal tasks. Each team comprises of 1 solicitor, 1 barrister, and 1 DOJ counsel. So one team is called the Paper Pioneers. So this is the team that would rely solely on traditional methods. The other team is called Algorithm Avengers. So this is the team that will have the assistance of AI. Now, this game has been pre-recorded and we'll be replaying some of the highlights on stage shortly, after which we will then run a live poll and invite all of you in the audience to participate in a live poll to choose and guess which team is the Paper Pioneers, which team is the Algorithm Avengers. And after these 2 rounds, participants will then come onto the stage and reveal the true affiliations. After which, we will then invite the participants and the judges on stage to share a little bit of their experience and insights based on the game. And without further ado, let's invite our participants on stage.
First, we have Team A. Please welcome Mr. Albert Xu, a public prosecutor from the Department of Justice, Ms. Christy Chak, a barrister from Erickson Chambers, and Ms. Vivian Young, a senior legal counsel from KN Group.
And then next, we will invite our Team B. So let's welcome Mr. Felix Tang, who is a barrister from Courtyard Chambers, Ms. Hemans Leung from JC Legal, and Ms. Karen Lee, a public prosecutor from the Department of Justice.
So for round 1, we are honored to have our esteemed panel of judges. Firstly, we have Ms. Deanna Law, a barrister with extensive experience in civil and regulatory practice with a deep bench of expertise in land and trusts, general commercial law, and medical negligence. Joining her is Ms. Karen Cheung, a partner in the Hong Kong Office of International Law from Holman Fenwick Williams, LLP, with expertise in complex cross-border corporate and commercial litigation, international arbitration, banking and finance, white-collar crime, and regulatory matters. Will the judges please remain seated at this time, and we'll invite you onto the stage shortly. Right. So let's dive into our first round. Very exciting, which was the speed challenge. In this round, both teams will tackle a hypothetical legal question requiring an urgent application for an injunction. Innovation Limited is a contractual dispute with its former supplier, SupplyLink Limited. After commencing legal proceedings, Innovation learned that SupplyLink is transferring its assets out of Hong Kong and have sold properties below market value. Innovation then decides to apply for a Mariva injunction against SupplyLink to avoid the latter's disposition of assets. Each team will have 45 minutes to conduct their research and prepare a short, succinct written submission outlining the grounds for the injunction and the terms of the injunctions in order for innovation. One team will rely on printed materials and traditional electronic research tools, while another will utilize AI-powered legal research tools in addition to traditional resources. After the submissions, our esteemed panel of judges will review the written submissions, followed by a 15-minute oral Q&A sessions, allowing the teams to further defend their arguments and engage with the judges' inquiries.
Now that we have had a good look of both teams, perhaps we can invite them back to the seats, and then afterwards we have pre-recorded this speech challenge, and then we can have a look at the highlight video. So perhaps both teams, thank you very much, and you can go back to your seats. Thank you.
Welcome to LawTech Guess Who. Today we'll have two teams of participants, the algorithm Avengers, who perform our legal tasks with AI tool, and paper pioneers, who will utilize the traditional method in completing legal tasks. Let's get started by having our law storing sessions.
Part of the expiring application, as you're aware, you need to have full and frank disclosure. So in your study submissions, it appears that you have not touched upon what is the possible effects, counterclaims, or like what full and frank disclosure should be aware of. It seems that you don't. So only claiming half of that, presumably that amounts to half of the price that's given. So, but you only need 6 million for the good ones with that. So, how about the remaining 9 million? Is there a counterclaim or is there going to be settled between the parties?
My lady, I think the plaintiff has a pretty strong case for the breach of contract. First one is for the late delivery without valid excuse. The other is the delivery of the defective laptops. And in terms of this application, because it is a Mariva injunction application, we have a really strong evidence against that, that the plaintiff are trying to dissipate the assets.
Due to supply chain disruptions, which is simply unbelievable as the contract has been signed on 10th of October and delivery dates have been well set out, but they could only manage to do so after on 3rd of February, and which is also fraudulent misrepresentation.
that is larger in sum compared to your claim of 4.5 million, that should be put aside and ignored at this stage, and we should just focus on your main claim.
There's no suggestion that we have affirmed the contract. We complained, we raised the issue 5 business days as per the contract. So what we're saying is, at the very least, because there is a reprieve period, that the plaintiff should be allowed to insist on not paying the remaining 18%.
There is still time of 3 billion account, and those there's no evidence from your end that to automatically resolve. So is this an appropriate case to grant an injunction or damages?
But there is a track of withdrawing funds with the account as considered under paragraph 9, paragraph 3, that the defendant is withdrawing funds at a rate of around $5 million per day. So by the time when the case goes into the substantive hearing, then the fund will have to disappear. So which renders it evident that any kind of appeals that supply links do have appeals with them. And so the worst case scenario is that they can take dollars from the bank tomorrow, then they still have to
So tomorrow, let's say, money then you ask the court at least to freeze the bank.
So first of all, congratulate to both teams. You have done an amazing job because it's extremely difficult to prepare such a very comprehensive submissions within a very short time frame. The two skeletons were well polished, very well structured. All of you, I suppose, make very good use of your resources, be that paper resources or AI resources. We'll know later. Maybe the limitation or the improvement that you could have is whether you're able to find cases with more similar types. I think it would be much more helpful, and in real life you probably have the time to find directly relevant cases and perhaps even cases with similar contractual clauses and see how they are interpreted by the court. The counterclaim of the defendant may even be higher than the claim of the plaintiff itself. But I think when you're preparing this skeleton, at least you have to foresee what the judge will ask. I think that is the most challenging way. The way that they say, okay, if I'm in court, I'm making this application, what will the court ask me? For case law, AI can assist you. But the strategy of the case is really based on experience and also a feel of the commercial sense of what's going on. The most human part is how do you phrase the question or the scenario or issue in order to get helpful assistance or even answers from relevant research tools. And I think with the assistance of your research tools, how to frame a scenario would be a challenging task for all of us in the future in order to properly help you answer.
Let's have a look at the key points and submissions from both teams, which are now displayed on the screen.
Okay, I think you all had a good read. So the next part is there's a QR code on the screen. So you can scan that and go into the live poll and indicate which team you think is the algorithm Avengers, which is the team that is using AI. So there's Team A and Team B.
just give it a couple more seconds to allow people to scan the QR code, and then we'll be able to see the results. Now, here we are. Let's look at the results of the poll. Please note that the identities of the team will be revealed after round 2, so let's stay tuned. Ooh.
Very close.
It's really interesting. 63 people, 64 people, 67 people are voting, 70 now. Team B. Ooh. It's exciting, actually, very exciting. Great.
We'll wait for those 2 participants after voting. Okay, 77 votes. Not bad. So we'll cut off here. Before we reveal the truth, we will look into the second legal task, which is the strategy challenge. Now, in this round, the participants in both teams have been asked to look at a set of case facts and then to predict whether the outcome of the case, how that would look like. So on the screen, you will see some of the broad case facts.
So again, the team has 30 minutes to formulate these predictions. One team will rely on experience and traditional tools, such as law books and non-AI-powered electronic legal databases, while another team will utilize AI tools in addition to traditional tools.
Just to bring everyone here through the facts, so this was a case involving a defendant who was charged with assault occasioning actual bodily harm, AOABH, under Section 39 of the Offences Against Persons Ordinance. This incident occurred on the 28th of November 2024 at a parking area near Central at 9 Edinburgh Place in Central Hong Kong. Now, this dispute arose between the defendant and somebody called Cheng, where the defendant admitted to shoving Cheng in an attempt to maintain distance during a heated exchange. This altercation ultimately resulted in injuries, which led to Cheng's collapse and death. The defendant asserts that he has acted in self-defense and contends that the prosecution has failed to take into account and establish a direct causal link between his actions and Cheng's death. The teams have 30 minutes to predict whether the defendant will be convicted or not, along with a short oral advice and on the reasons for such predictions.
In the interest of time, we've already pre-recorded the preparation and the team's oral advice. Let's watch a short highlight video of the teams in action.
In this case, the defendant claims that the shove was to keep distance after Zheng advanced aggressively, and the block was to protect his sister from perceived harm. Zheng initiated physical blows thereafter. If in the car videos corroborate Zheng's aggression and defendant's defensive posture, this will strengthen the self-defense claim, and the proportionality test will be the key. A shove and block can be reasonable responses to an advancing aggressive person.
In our view, there are some weaknesses for the prosecution's case. First, there's no direct witness to initial altercation. And second, the medical evidence undermines causation. It points to the complications died from the epilepsy, but not some injuries from the assault itself. Third, the defendant's acts might constitute self-defense. They were plausible and proportionate and was not disproved by the prosecution beyond reasonable doubt. And fourth, the video may support defensive conduct, and we are of the view that the defendants will likely be acquitted of this offense.
As an overview, the admitted facts only shows there is an assault. It fails to show any assault between the parties, and the medical report adduced as an evidence only shows to the extent that the cause of death also the timing of death by the deceased, but it could not show any harm of actual bodily harm caused by the defendant. Further, the two witnesses called by the prosecutions does not support the elements. First, it is not eyewitnesses. Second, it only shows the event after the deceased has been collapsed.
Now, applying it to the facts of the case, and according to defendant's evidence, we say that the two occasions in which the deceased was inflicted force by the defendant were actually due to provocation or the use of force from the deceased, meaning self-defense. In the facts, we see that when the deceased suddenly advanced and caused his chest to collide with the defendant only shoved the deceased to maintain distance. Assuming this is believed by the court, this is obviously a proportionate reaction to this. Secondly, when the deceased tried to strike the defendant's head with his fist, the defendant only raised his arm to shield himself. So judging from these facts and from what we have said, we are of the view that the defendant will be acquitted.
Now, on the screen, you will see the key points of each team's prediction, along with their ruling and outcome of the actual case. So we'll leave it on this slide for a little bit for you to take a good look before we shift to the live poll.
Same as the previous round, we would invite you all onto the poll, to help decide who is the paper pioneers and which is the algorithm avengers. Please scan the QR code and we can start the poll. Let's take a look at the results of the poll. I think we have a clear winner here, Team A. 81 people voting, 44 people still participating. I think that concludes Team A, Algorithm Avengers. Right, so now let's invite our participants to reveal their team affiliations and share their insights from these mini games. We'd also like to invite our esteemed judges from round one, Ms. Deanna Law and Ms. Karen Chung, to come on stage to share their observations.
Participants and judges, please come up onto the stage. So perhaps the judges could stand in the middle. We could have Team A on this side, and then Team B on the other side. So, Team A, could you identify yourselves just for the audience to have a clear ID?
We are Team Algorithm Avengers, so we're the team that has a fourth member, that's the AI tool.
And so Team B would be the paper pioneers that is using traditional methods. So it seems like this is aligned with the audience's polls and guesses. So without further ado, we do wanted to ask you guys to share a little bit of your insights and learnings throughout this experience. So perhaps we will direct some of the questions first to Team A. So Team A, you had the advantage of using AI. Obviously, in such short of a time, it might be a little bit overwhelming as well. So could you walk the audience a little bit on how you interacted with the AI? What was AI? What was not AI? Were there any learnings? What was good and what wasn't good?
Hi, so I'm Vivian. We do have the advantage of having AI to assist us with this process, and I think it serves as a really good, first draft assistant for us when we were commencing, this exercise. In that it was, the AI tool was able to generate a very, comprehensive and the basic structure and content of as a starting point for us to begin with, and so. As you all would know, we'll have to first, train the AI tool by, feeding in the materials. We've quickly converted, text, for AI to learn and understand the case. And then just within a minute, we were able to, get a quick first draft. But very soon, we've noticed that, there are actually quite some flaws within the document, including, for example, on some of the arguments were actually quite vague and lacking of substance. So one of our members actually, so we have allocated among ourselves to take care of each section. And one of our members, covering this section, started to work with another AI tool, adding the 5th member to our team, and to improve that part of the content. And another example I would raise is, the legal principles part, where, the AI tool was able to, generate some of the useful white book provisions, but perhaps lacking of, case law in support of that application. So our very experienced barrister also quickly pulled out some of the authorities and added it back to our draft. So I think all in all, in this process, our key takeaway is that AI is a good starting point, but you could never compromise the final judgment that would need human inputs, and always test the AI products with your own knowledge, your notes, and the evidence you have in hand, and it would be really helpful, especially timing when timing is critical, and when you're working under time pressure. Yeah, thank you.
Thank you, Vivian. So just a bit of a takeaway for everyone here. It seems like what Vivian mentioned quite a few times is using AI as the starting point. So AI has the advantage of helping you go through voluminous work in a very short span of time to quickly identify insights, but ultimately you need the human input subsequently. And the second point is that in reality, you might be using a blend of different AI tools and not just one single tool, it seems. So thank you very much for Team A's contribution. Perhaps we can direct some questions to Team B.
Thank you, Stephanie. So the paper pioneers, good job. How did you approach the tasks using traditional methods? And how did you manage the time constraints? Probably when you're using AI tools, you probably traditionally maybe save some time here and there. And my second question would be, as part of that, supplement that, any points where you felt that you could use some technology to help optimize or improve your output?
Hi, I'm Felix. And basically, I think we knew we were really short on time. So thankfully, it was a Moravian junction. So I think a lot of us had done it before. So basically, we just took out a president and we just edited on top of that submissions. So that was not using an AI tool at all, but because it was not something very novel in that sense. So we just used a previous case that I worked on, and then we put it on a Google Doc, and then basically we could retain all the legal principles. But onto your supplemental question, I think what took us a lot of time, and my colleagues can attest to that, is summarizing the facts. Because with an AI tool, we could just prompt them, give them the facts, and then they could help us summarize in a more succinct way. But we really had to read the whole thing and then really manually type out every bits of the facts and application as well.
Oh, and also I think because of the time constraint, we don't really have the time to put in the fact pattern. Whereas let's say for some of the AI tools that we can actually put in fact patterns so that they will generate some of the relevant case laws for us to read. But without the AI tool, then we're not really able to find similar case in such a time constraint. So that's why we really need to rely on some of the precedents that we have in hand, and to just, especially for the case prediction. So we really need to use our own previous experience to predict it. Yeah.
Well, thank you, Team B. Just following Felix's point, you mentioned that it was helpful you guys had the expertise and past precedents previously, and that really helped giving you an advantage and starting point. I wanted to go back to this team. Given that this team has different levels of seniority and expertise, did you feel like that mattered or impacted how useful the AI was for you?
Thank you. I'm Albert, and regarding this question, I have two observations. First, being senior may be a good advantage, because when we face the question, even without using the AI, we can easily have a quick view. For example, in the question 2 about whether the defendants will be likely convicted or acquitted, and if we are experienced enough or senior enough, we may think about what we have done in our daily practice, and we will easily form a view. And after we get such a direction, and we have the assistance of the AI, and we will easily formulate our argument. And I also observed that, and no matter how senior we are, the method we need to use, or the skill, is actually how we instruct the AI. For example, if we ask the AI to generate a draft, and there may be something that's not specific enough. And we also need to check whether the authorities cited by the AI draft are accurate, or whether the summaries prepared by the AI are precise enough. And regarding this kind of skills, and no matter we are senior or junior, and insofar as we got the skills of how to instruct the AI and how to ask them further questions precisely, AI would become a very good tool for us in our work, no matter legal practice or even our daily hobbies and etc.
Actually, during the competition, we found out like one of the cases is fake, that we're pretty sure that it doesn't exist in the real world. I think the key takeaway is that not a lot of information may not be as helpful. It may slow us down. I think we need like proper like trainings on how to ask the right questions, use the right prompts in order to use AI effectively. I believe like AI can be a powerful tool, like with proper trainings and like with ongoing technological improvements in the future, but it can only act as a starting point to quickly give us guidance and like broad directions on how we should approach the case. It cannot replace human lawyers in building like strong arguments or applying sound judgments and applying the facts as well.
Thank you very much, Albert and Christy. So I think the points that we can extrapolate for the audience here is that for successful implementation and usage of these sort of technologies, it comes also with keeping human in the loop, but also having the proper trainings and processes in place. So perhaps we can pass some questions to the judges. Now, we'll direct the first question to you, Deanna. So you have the opportunity to review all the submissions, oral and written, from both teams. Were there any sort of things that you thought it was very good, what was not so good? Any general comments?
Afternoon, ladies and gentlemen. I'm Deanna Law. So we had the pleasure and opportunity to take a look at the written submissions as well from both teams. And that was quite interesting for both Karen and myself, we thought, because the one team's written work structure was a little bit different from how we would normally approach a case as a practitioner. So we thought that was some kind of wink-wink factor to show that there was a fourth or fifth member to their team. So you didn't have the opportunity to see the written work, but I think it's actually more obvious if we were given the written part. And in terms of approaching the matter, we found that eventually we did make a guess, and both Karen and I actually made the right guess as well, judging from the product and the way the written work was approached. And we found that sometimes the AI-assisted product seemed to have generated some irrelevant materials like case law or not very accurate summaries, things like that. So they were quite obvious, we thought. So as I think I've commented in the video as well, I think the way ahead or the takeaway and the thing for us to learn is to how to properly use the potential and the depths of these tools, how to input the appropriate prompts or the scenario to assist us. But of course, the human part of it we found made a difference, because in the oral submissions part, both teams actually approached the legal question consistently. So us as humans, we did make use, I could see from both teams that they made use of the traditional tools as well as the AI tools, but the oral part of it did not make a big difference. So that's how I saw the input of the AI in this game, and it was an eye-widening experience for myself as well.
Thank you, Ms. Deanna Law, for your insights. It's fantastic. Switching gears to Ms. Karen Cheung. As a partner of an international law firm, any general comments on the use of legal technologies playing an important role in legal services?
Well, indeed, our firm is actually the pioneer or one of the first international law firms to use AI tools to do research, writing. And my trainee here today, he's very blessed to have these tools to assist him. And I remember 23 years ago when I was studying the law school, I have to stay or actually live in the library to find the relevant journals, legal reports. And so the difference of legal junior trainees these days is as what Dr. Horace Chung, Deputy Secretary for Justice, mentioned in his keynote speech, is EJI. One have to have empathy, judgment, and also integrity. Nowadays, with AI tools, with the correct prompt, that means input, and with a reliable LLM, large language models, which means ChatGPT or some of the legal tech AI tools, you can be a good lawyer. Everyone can be a good lawyer. But what makes a good lawyer, from a good lawyer to a great lawyer, is one to have empathy, integrity, and judgment. And it needs experience, it needs hard work, and it also needs grit. And on this, I note that I don't have a lot of time. We only have like 1 minute left. I'm actually wearing 2 hats today, not only as a partner of an international law firm, but also a council member of the Law Society. With this, I hope that everyone in this room, especially legal practitioners, have empathy and compassion to the tragedy in the Taipo fire. And we have recently set up a hotline so that all the lawyers can be a volunteer to help those who are affected by the Taipo fire to provide legal assistance. And this can be done by volunteering yourself, by being a volunteer of a helpline. The number is 2840-1011. So I can recite this. 2840-1011. Alternatively, now you can go to the Law Society website and sign up as a volunteer for the on-site legal advisor for those who actually are living in the transitional home in Taipo. So this is starting from yesterday until further notice. So I don't think AI can actually help those distressed residents in the Taipo for all these for all the legal problems they are facing, for all the depressions, for all the emotions they are facing. But with human, we can actually help them during this difficult time. So thank you very much.
A big thanks to our participants for the valuable insights. Now let's summarize the key points from today.
Yep. So I think in terms of the key points, there's quite a lot that we have shared, but to extrapolate and reduce it to 5 key points. First, I think it is quite clear and established that we must keep human in the loop in the usage and interaction with these sort of technologies. And second, it's not only human and technology, but also training and process, and a process to check these outputs to make sure that we're using these sort of technologies in a safe and responsible way. Thirdly, from a strategy perspective within your organization, you might be having to look at multiple tools and multiple AI technology-based tools to achieve the optimal results. The fourth is that to be using these sort of technologies or AI, as Felix has also pointed out, you will probably need to have a good eye and good management of your existing precedents as well before you layer these sort of technologies on top of it. And last but not least, as Karen has nicely really pointed out is that the human value, for example, empathy, judgment, and strategy, these are all qualities of lawyers that can never be replaced by technology. So that concludes this session. So perhaps we can invite everyone on stage to stay on stage and we can take a photo together.
Group photo.
Yeah.
Thank you, everyone. Please follow the instructions from our lovely photographers. And once again, thank you, Mr. Fu. Thank you, Ms. Yu, for being our moderator. Thank you to our judges. And of course, Team A, Team B, thank you for being with us. And don't forget, we have video after this as well. So everyone, please hold on to your best smiles. All right, just make sure we have that other video going as well, I believe. Wonderful. Thank you very much, everybody. Thank you for that insightful sharing and that wonderful session. Everyone, please take a seat. Thank you once again. That was wonderful. Thank you, thank you. And thank you to our two moderators. Please be seated. With appreciation. Thank you. Okay, after the LawTech Guess Who, we will have the LexGoTech Roundtable Series 2025 final round. Now, this session will kick off with an introduction of the LexGoTech Roundtable Series and the much anticipated roundtable report. Now, not only that, following that, there will be an interactive discussion session where there's panel speakers who will exchange their views and also on their key findings in the roundtable report. The audience, everyone, will have the opportunity to participate in the interactive polls on their take and also their key issues that they're presenting. Please note that this session will conclude with a summary of the key takeaways by our lovely moderators. Now, as we're setting up on stage for this next segment, everyone, please keep your eyes and your ears peeled as this will be another exciting session that is happening. And for this, I will invite our moderators to join us for this session, making sure everyone have what they need. Perfect. Thank you very much. Can I please have Ms. Leonia Chung and Ms. Sharon Chung to please come on stage. Now, just a bit about them. Leona is the Prince Government Counsel of the Legal Enhancement and Development Office of the Department of Justice. Now, Ms. Sharon Chang is a member of the Department of Justice Consultation Group on LawTech Development, as well as a director of PwC Hong Kong. Next, we will invite our distinguished speakers, Mr. Ho-Tak Leung, Mr. Carl Lee, and Mr. Edward Taylor, as well as Ms. Michelle Taylor, to all join us on stage. Everyone, please make yourself comfortable. Yes, you will see your name behind your seat. Perfect. Ms. Chung and Ms. Chang, I will hand it over to the two of you. Thank you. And please start with a group photo just to make sure we get that out of the way before we start, of course. Just make sure we have the best shot there. Just a few more. And the video, don't forget. And one more official photo, of course. Ms. Chung and Ms. Chang, please.
distinguished colleagues, indeed, the Honourable Paul Lam, Secretary for Justice, distinguished colleagues, members and friends of our Hong Kong legal profession, thank you for joining us for today's LexGoTech Roundtable session. The work we do together across practice settings, disciplines and institutions shapes not only how legal services are delivered in Hong Kong, but also how trust, fairness and the rule of law are advanced in a rapidly evolving digital era. Hong Kong's legal sector is moving through a period of purposeful transformation. LawTech, including AI, is gradually progressing from pilots and experimentation to more meaningful deployment of legal research, drafting, translation, document analysis, e-filing, virtual hearings, training and online dispute resolution. The momentum is sector-wide. Solicitors, barristers, arbitrators, mediators, in-house counsel, government lawyers and legal educators are all engaging with technology in varying degrees with the aim of improving quality, expanding access to justice, and meeting rising client expectations for timeliness, transparency, and value. Across the 3 Department of Justice LexGoTech Roundtables held this year, participants reported that LawTech can deliver measurable efficiency while reinforcing human judgment, freeing practitioners to focus on more complex matters, on higher value strategy and advocacy, and to devote more time to understanding client problems. While our Hong Kong legal profession is in the relative early days of this transformative journey, Hong Kong champions the wide and responsible adoption of AI and LawTech under clear professional guardrails. That commitment is not merely thematic, it's operational. It includes confidentiality by design, robust data governance, provenance and citation verification, human-in-the-loop oversight, and proportionate risk-based controls. It also means addressing cost barriers and capability gaps through collaborative initiatives, improving access to secure platforms, and supporting training that equips practitioners at every stage of their careers, including through university legal education, with the skills and discipline to adopt and use technology responsibly. This is central to Hong Kong's competitive edge. Responsible adoption of LawTech and AI consolidates our leadership in international legal and dispute resolution services by combining efficient technology-enabled workflows with the professional rigor that clients, courts, and our counterparties rely upon. It preserves ethical practice and public trust while enabling new models of service delivery that scale quality, widen participation, and enhance access to justice. It is not technology for its own sake. It is technology in service of legal excellence. Our final LexGoTech Roundtable today will consider practical pathways for LawTech adoption, firm-level and industry-level governance, equitable access for small and medium legal practices, and future-ready professional standards. We will also acknowledge and address the risks of use of LawTech and AI, such as privacy, accuracy, bias, hallucinations. Through disciplined oversight and clear policies, we can keep lawyers accountable for outcomes. Importantly, we will explore how LawTech strengthens, not substitutes, the human skills at the very heart of our profession: judgment, advocacy, ethics, and client care. As we continue this dialogue, let us align on a simple proposition. With prudent guardrails, LawTech and AI can enhance quality, efficiency, and access to legal services while upholding the standards that define Hong Kong's legal system. That is how we safeguard public trust and reinforce Hong Kong's position as a leading international legal and dispute resolution centre today and over the long term. Now, against this background, we're now going to involve you in a quick online poll using the QR codes on your phones on the screen. And the question that we're going to ask is, on a scale of 1 to 10, how would you rate the use of LawTech or AI in your legal practice? 1 means you never use LawTech or AI. 10 means it's an integral part of your legal practice workflow. While you're doing that, let me continue. There will be 3 more polls after this one using the same QR code, so please keep your phone handy for those additional polls. And your active participation in these polls will be insightful. We'll share the results of the 4 polls with you at the end of our panel discussion. So the rest of the session will flow as follows. I'm shortly going to hand over to my co-moderator, Leona, who will explore the continuous policy support for the development of LawTech and legal AI in Hong Kong, and share some further insights arising from the LexGoTech Roundtables. After Leona has addressed us, Leona and I will facilitate a panel discussion as our final LexGoTech Roundtable for the year with 4 very experienced legal practitioners who have hands-on experience with LawTech and AI. Mr. Carl Lee from Linklaters, Mr. Edward Taylor from A&O Sherman, Ms. Michelle Taylor from Tiang & Partners, and Mr. Hoi Tak Leung from Ashurst. We've observed that many of the early LawTech adopters and movers in Hong Kong are, understandably, from the larger international law firms or networks. However, we also know and expect that over time, many more local law firms, barristers, arbitrators, and in-house legal practitioners from both the private and government sectors will be actively using LawTech and AI technology. And we look forward to more voices joining the debate to share their experience over time. So let me now hand the floor over to Leona to take us through some interesting insights and observations about what has been happening with LawTech and legal AI in Hong Kong.
So good afternoon, everyone. Over the past 6 months, over 70 members of our legal profession, including solicitors, barristers, arbitrators, in-house counsel, government lawyers, and legal educators, came together to answer one central question. Sorry. The question is, how should Hong Kong's legal profession navigate the AI transformation? Today, it's about sharing what those practitioners told us, why it matters to us, and to take the conversation forward. But first, let's take a brief look at how we got here. A good starting point would be the year 2018. That year, eBram International Online Dispute Resolution Center was established, and it provided an efficient, cost-effective, and secure online dispute resolution services. Since then, eBram has expanded into a suite of platforms, including the APAC ODR platform, an online arbitration and mediation platform, and a deal-making portal for quicker and cheaper resolution that overcomes geographical and language barriers. This has helped put Hong Kong on the map in the digital dispute resolution landscape. Then came 2020, when the LawTech Fund was launched to help small and medium-sized firms and barristers' chambers to upgrade their IT systems and skills. Over 500 applications came in, covering about 70% of the target law firms and chambers. That is a strong signal that the profession was ready to modernize. 2 years later, the Hong Kong Legal Cloud was launched, a secure, affordable platform for storing and sharing documents with more than 4,000 subscribers, subsidized for up to 3 years. These initiatives laid important building blocks for Hong Kong's LawTech ecosystem. That's why, when the chief executive in the 2024 policy address set out a policy commitment to promote LawTech in the legal sector, it was the logical next step. Earlier this year, the consultation group on LawTech development was established, advised the government on policies and measures for the wider adoption of LawTech across the profession. From the discussion with the consultation group emerged a clear strategic framework. And this is what it looks like. There are 3 phases. In the first phase, we deal with the foundation, which concerns awareness and education. The initiatives under contemplation included building understanding through roundtables and knowledge-sharing events, discussing with law schools to integrate AI and law tech literacy into curricula, and developing practical roadmaps and ethical guidelines to aid practitioners embarking on or advancing the law tech journey. Phase 2 was engagement that concerns product matching. We consider it helpful for practitioners and service providers to connect more directly through product parade and demonstrations, allowing practitioners to consider what tools fit their needs. And we also conduct market survey to help identify ecosystem gaps and opportunities. The third phase is implementation. We hope to see ecosystem development deepening through enterprise growth support, framework refinements, and continuous feedback to ensure that adoption is sustainable and aligned with Hong Kong's regulatory and professional standards. This framework has guided our work throughout 2025. That is a year of accelerating momentum for Hong Kong. As mentioned, the consultation group was set up in early 2025, and the three-phase strategy was formed. Then we took steps to bring those strategies into reality. First, the LexGoTech Roundtable Series was launched in June. In parallel, we launched a survey of law tech service providers in Hong Kong in September to map out our local ecosystem. Also in parallel, we are discussing with universities on strengthening law tech readiness in legal education so that our future lawyers will be prepared for an AI-enabled legal landscape. And this week, we are having the inaugural Hong Kong LawTech Fest with the LawTech exhibition just next door. And for those who haven't done so yet, I warmly encourage you to visit the exhibition next door after this section. It closes at 5:30 p.m. today, so grab the last chance. And last but not least, in a moment, we are releasing the LexGoTech Roundtable's report, a document that captures and distills what those 70 petitioners told us. So a little bit about the roundtables first. There were 3 focus roundtables which were held in June, August, and October this year, and it gathered those 70 members of our legal profession I mentioned to share real experiences, candid concerns, and future plans around law tech adoption in their daily work. The conversations were frank, practical, and enlightening about what works, what does not, and what the profession needs in order to move forward. These are some of the key questions that we asked. The ways they were using law tech, how that has changed their work, how they see the future of legal practice with the rapid growth of law tech and AI, the risks they see, how they are gearing up for the AI era, and what qualities they would like to see in our next generation of lawyers. Now, before we dive into how the profession answered these questions, ladies and gentlemen, this is the moment we release the LexGoTech Roundtable's report. You will see a QR code on the slide. Please do scan it and download the full report. It is now publicly available also on the Department of Justice website. It captures the voices of the 70 participants in the roundtables, the themes that emerged, and the practical insights that will shape our next steps. I'll give you a moment to download the report. So with that in hand, let me walk you through the key findings. The report identified 4 recurring themes. First, increased efficiency. Participants reported genuine productivity gains from using AI for legal research, drafting, translation, etc., and they are redirecting the saved time to higher value work and client strategy. Importantly, many feel that technology is a potential equalizer, giving smaller firms access to capabilities previously available to only larger practices. Second, ethical considerations. Participants raised concern about data privacy and confidentiality, accuracy and hallucinations in AI output, and accountability for AI-generated work. There was general consensus that technology must operate within professional guardrails. The third theme is regulatory frameworks. With AI use being increasingly prevalent, many saw the need for updated internal guidelines and professional guidance. Clear guidelines on how AI can be used and how to make clear that the work product ultimately remains the lawyer's responsibility. The fourth theme is awareness and education. Educating legal professionals is necessary, but considered not enough. Many participants pointed out that the clients and the wider public also need to be educated so that they will understand what AI can and cannot do in legal matters. And legal educators also emphasize the desirability of integrating AI literacy, data ethics, and critical thinking training into law school curricula. So here we are, at the 2025 final round of the LexGoTech Roundtable Series, with the report in hand and a clear sense of where the profession stands. It's time to talk. But before we do that, I have to ask you two further questions. The question is, please name one use case you implemented this year that demonstrably improved turnaround time and quality in your legal work. Thank you. The next question is, what is the greatest hurdle in your or your organization's LawTech and AI adoption journey? The answers are on this slide, and I won't read them out. So while I leave you to answer the question, I'll pass the time back to our roundtable discussion.
Thanks very much, Leona. And so now let's kick off this LexGoTech Roundtable discussion. And Edward, let me start with you with a question. Now, your law firm, A&O Sherman, has been using LawTech and generative AI technology really as a first mover with your very early pilots and then adoption of well-known third-party legal domain-specific Gen AI technology. One of the biggest practical hurdles lawyers face when considering LawTech is where to start, because there's a necessary investment of both time and, of course, money to procure the right technology, roll it out, learn how to use it. So can you share some practical tips on how a legal practitioner or a law firm can get started with LawTech? And what sort of tasks or processes would you say a lawyer could easily use with LawTech or AI?
Certainly. Thank you very much. We've already heard a lot of very valuable insights today and practical tips, so I'll try to be very brief. But I think a really important overriding principle when you're looking at starting to use LawTech is to, first of all, start. It's important to start and try this new technology, this interesting developing technology, but start small. Start with something that's manageable. And what that really means is to start with proven low-risk use cases for LawTech that can be easily monitored by lawyers to make sure that they are doing exactly what is intended. And often the most obvious starting place is high-volume, document-heavy tasks that really benefit from human-in-the-loop oversight. And you asked about what practical examples LawTech can be used for, and obviously there are a huge variety of tools out there offering all sorts of things, but a good starting point is things like reviewing large sets of documents, reviewing large sets of contracts to identify specific clauses, compare them against precedents that you already have in your system that you know are safe. Also things like summarizing large sets of documents, performing first-level translations, preparing things like chronologies, timelines, list of issues, and obviously you need to do that in conjunction with a rigorous internal checking process to make sure that those are accurate. Other things that can help drive efficiency, so using familiar tools, things like Microsoft 365 already has some built-in AI features that it may be appropriate to use, and those can really help with drafting and editing and speeding up work processes like that. And finally, as we saw earlier today in the very interesting presentation that came before this, there are some tools that can be used for research assistance and knowledge retrieval, and obviously, again, you need to use careful safeguards, but there are some very interesting tools out there for that. The final thing I'll say is that we often talk about how these tools can be used on matters for things like research, but they also have other applications that can be useful within a law firm. For example, managing matters. So helping to prepare documents that will create phases of different work or allocate work between different members of the team. That's another potential way that these sorts of tools can help to drive efficiency within a law firm.
Edward, thanks very much. And in the interest of time, we're going to just ask each panellist one question each. And I'm going to hand over to Leona, who's going to ask Michelle a question.
Yes, thank you, Sharon. And also in the interest of time, may I invite each panelist to answer the question really succinctly within a minute. I apologize for that. So Michelle, I have a question for you, and that is asked on behalf of the small and medium-sized firms. How may small and medium-sized law firms practically benefit from AI transformation despite limited resources?
Thank you very much for your question. So I'm speaking as a managing partner of a small firm here in Hong Kong, but I am part of a network of law firms. So I was able to benefit from our network's collaboration with a legal tech tool and be able to use that for the last 2.5 years. And on the panel question you asked earlier about usage, I would say that I was at an 8 usage on a daily basis. So I think talking to the sole practitioners and the small firms here, I would say do not be scared about the jargon, do not get overwhelmed by the concept of tech. What you're actually hiring for your firm in acquiring some legal tech or tools like AI tools is a very competent junior lawyer. In fact, probably top of the class, very good at communication, very good at listening, very good at drafting, better than anyone else can probably draft in the office, but also sometimes a little bit stubborn and pig-headed and might head off in their own direction, so they need guidance. And this comes back to the comment by our moderators of the last session. The human must stay in the loop. So you would not leave your HR person to go and hire somebody that's going to be your right-hand man. Similarly, don't leave your young lawyer who professes an interest in IT or your IT guy, if you're so lucky to have one, to go and find the right tool for you. This is a tool for lawyers. It's not a tech. It's not the answer to all your problems. It's not going to solve all of your issues. It's a tool that you will use to produce documents or do the things that Ed mentioned, which I think are all pretty straightforward. I've noticed in dealing with some of the legal tech providers that they tend to have tech people with a legal background, but actually ultimately tech people doing the selling. And they dive in very deep and give you loads and loads of ideas of the things that you could do. But actually, it's another point that Ed made is just get on with it, get started, start playing with it, start using it, and then you'll find that it comes naturally after a while. So we're lucky in Hong Kong that the Law Society has taken quite an active interest from day one in legal tech, and obviously the DOJ is doing an excellent job now and the government in pushing the narrative as well and looking into legal tech generally. There are lots of tools available. Talk to other small practitioners, friends in the market, find out what people are using. Give me a call, drop me an email. I'd be happy to chat about what we use. I've been using it, as I say, for 2.5 years. I've got a lot of insights. And try and work out from there what you would work best for your practice.
Thanks, Michelle. Now, Hoy, I'm going to ask you a question, but we are going to try and have to keep it down to a minute. The timekeeping here might be a little bit different. And we want to pivot and talk a little bit about risks. So many lawyers are concerned about the use of generative AI technology because of privacy and confidentiality risks, especially in relation to client and law firm data, and the obvious risk that Gen AI can hallucinate and generate incorrect responses. So what sort of practical guardrails did Ashurst put in place to enable lawyers to use generative AI responsibly, but without slowing the work down?
Thank you, Sharon. And before I answer that question, I want to thank the Hong Kong government and DOJ and the Hong Kong Law Society for organising this week and also today. Lots to talk about, so hopefully we can keep the discussion going on after today. Now, to what you mentioned, Sharon, I mean, typically I would present on this for 50 or 60 minutes, but I'll keep this to a couple of minutes. I think just a couple of things. We're a global law firm, and we obviously have duties to our clients and to the profession in a number of different ways. And so the way that we have set up is a very comprehensive way of both looking at different governance protocols, for example, which vendors we use, how we vet the tools, the policies internally that we have for our staff to use it. And also we have a strong focus on training. And that's probably the part that I wanted to talk a little bit about. As the Deputy of our Secretary of Justice said, the law ultimately has human touch. And so, we as a firm is always guided by some principles, one of those being we want to put the best tools in our staff's hands. And the practical reality is that if we don't do that, the staff will go look for their own tools a lot of the time, right? So, we provide the best tools to our staff. We give them comprehensive training before they can use the tools. And then after they start using the tools, we continue to support them in their journey. So one of the things that I do on a daily basis is to work with different practice groups, work with different teams, and just think about how we can use both AI and non-AI technologies to transform and improve the way that they work on a daily basis, both for our clients and for themselves. So there's a lot more nuances there, and just as Michelle said, if anyone has any questions, feel free to contact me afterwards. We have a lot of knowledge to share, but with that, I'll pass it back to you.
Yes, and for our final panelist, the million-dollar question. Many people say AI will replace humans. However, some people tell a different story and think that AI will provide opportunities to update and reshape our legal industry. What's your view? In 1 minute, please.
All right. Thanks, Leona. Thank you for somewhat of a challenging question. I think rather than asking whether AI will replace lawyers, the better answer would be the better question would be which part of lawyering would you rather leave to machines, right? As I've heard from my fellow panelists, we recognize that there are parts that AI are useful: e-discovery, doc review, due diligence. AI have significantly improved the efficiency of legal work in Hong Kong here today, and we have not seen the end of lawyering. So I think, lawyers are using AI to serve clients better, and we should think about what are the things that our clients always constantly are asking for, right? And they would say they want lawyers who deliver faster, at a lower cost, and lawyers who spend more time with them. So if you think about those criteria, you think artificial intelligence really has the potential of allowing us to deliver more of what clients want. Now, of course, I acknowledge that as a part of the question that there will be pressure put on the traditional leverage model. And maybe, there will be lesser of the so-called junior work around. But I think that's really, as what my other panelists have said, looking at redesigning the workflow. How do you design a human-in-the-loop process rather than asking our juniors to rely purely on their manual work? And I guess part of what your question is asking is, these hybrid roles, lawyering roles that also focus a bit on AI. For example, at Linklaters last week, we just launched our global network of AI lawyers and through our network. Now, these are experienced Linklaters lawyers who have been selected based on their experience, legal experience, as well as the knowledge to use AI tools and the delivery methods. And we firmly believe that that is a way that we will be able to serve our clients better on large, complex, cross-border matters. So I believe that the final message is that we should embrace the use of AI. Developing AI literacy will put us in a position to work better with AI. We do not want to find ourselves in a position where we compete with AI tools for the same task. And if we are successful in doing that, I think AI will not replace lawyers.
Thank you so much, Carl. So earlier we did 3 poll questions, but in the interest of time, I cannot reveal the answers, the results to you now, but that will be revealed on the social media of the lead office of the DOJ. So please stay tuned. And now I pass the floor to Sharon to do a quick wrap up for our section. Thank you, Sharon.
Thanks very much, everyone. I mean, it really now falls to me just to wrap up this final session of the 2025 LexGoTech Roundtable Series. Firstly, thank you to the Department of Justice for this innovative and meaningful initiative as part of Hong Kong Legal Week. To our expert law firm panelists for your insights today, albeit cut short, but as everyone has said, please engage in the debate. And of course, to every participant who joined the LexGoTech Roundtables, and importantly, to you as our audience, both in person and online, we hope you found this an eye-opening reflection, and we look forward to strengthening the opportunities for the entire legal profession in Hong Kong with the use of technology, AI, and establishing Hong Kong as the legal and dispute resolution centre that we aspire to be. Thank you very much, everyone.
Thank you once again for everyone on this stage. Can I please invite everyone to take a step forward and take a group photo before I have everyone take a seat and wrap up for today? Once again, thank you very much to both of our moderators, Ms. Zheng and Ms. Chang. Thank you to all of our panelists, Mr. Lee, Mr. Taylor, Mr. Lang, and also Ms. Taylor. Thank you. Always wish we had more time for these fruitful discussions. Everyone, please stay tuned on social media for the final reviews and results of the poll, as mentioned. Wonderful. Thank you very much once again. Everyone, please be seated. And thank you once again for that discussion. Thank you. Please don't forget your mobile phones as well. Thank you. Thank you. Ladies and gentlemen, we are truly privileged to witness two inspiring sessions this afternoon, which neatly illustrates how AI with human in the loop shapes the legal practice. Now, the integration of AI in legal practice represents a truly transformative shift that is enhancing efficiency as well as accuracy. This is by automating routine tasks. Now, AI allows legal professionals to focus on more complex tasks, as mentioned, and also to focus on relationship management. However, as we embrace these technological advancements, it is crucial to be aware and cognizant of the risk as well as the limitations of AI. The future of legal practice will undoubtedly be shaped by AI, and it is our responsibility to closely monitor its development in this process. Ladies and gentlemen, as we approach the end of this afternoon session, may I invite the Honorable Paul Lambton Kwok, GPS, SC, JP, Secretary for Justice, the Government of the Hong Kong Special Administrative Region of the People's Republic of China, to board the stage to deliver the closing remarks. SJ, please.
Distinguished guests, ladies and gentlemen, as we approach the end of the Hong Kong Legal Week 2025, I wish to extend my heartfelt gratitude to each of you for your active participation in the past few days, despite the difficult circumstances in our community. And we extend our deepest sympathies to all those affected by the tragic fire which took place last week, and remain mindful of the gravity of the situation as we bring Hong Kong Legal Week 2025 to a close. This week has offered us a valuable platform to engage in meaningful dialogues on various international, regional, and local hot topics. And this afternoon, we have explored the burgeoning possibilities presented by LawTech and artificial intelligence. This is a meaningful year for DOJ's annual flagship Hong Kong Legal Week, as we organize the inaugural Hong Kong LawTech Fest. LawTech and AI are not only trends to observe, but pivotal forces which are transforming the whole legal profession. During the Hong Kong LawTech Fest, we have explored how technological advancement are transforming the legal industry, enhancing not only efficiency, but also accessibility and quality. The significance of LawTech and AI cannot be overstated. The traditional methods we have relied on for long are now being complemented and in some cases supplanted by innovating technologies, which help streamline workflow and enhance efficiency. AI-powered legal tools facilitate a wide variety of tasks, including legal research, document review and drafting, contract lifecycle management, and e-discovery, and are significantly changing the way legal practitioners engage with their work. These tools elevate legal services quality by minimizing human errors, speeding up administrative tasks, and ensuring more accurate and timely responses to clients. Furthermore, the introduction of these technologies opens the door to a more inclusive legal landscape. The use of AI tools could facilitate access to justice through reducing the overall cost of legal services and making legal resources more easily accessible to individuals, regardless of their financial background. At the institutional level, they enable law firms, courts, and organizations to scale services, optimize resource allocation, and bridge gaps in access to justice. Nevertheless, there are two sides to every coin. As we embrace these technological innovations, we must not neglect the associating risks and ethical considerations. Throughout the discussions and the LexGoTech Roundtable report released today, we have acknowledged the dual nature of technology. While it holds the promise of efficiency and accuracy, it carries the risk of bias, challenges to data privacy, accountability, and transparency, etc. In the light of these risks, maintaining human in the loop is critical. We should not forget that while AI can process vast amounts of data with remarkable speed, advocacy, ethical judgment, commercial acumen, critical decision-making, emotional intelligence, and relationship building and management cannot be fully automated. It's therefore pertinent for us to adopt a human plus AI approach when embracing the use of AI so that we can harness the benefit of technology while safeguarding against its potential risks. It's imperative that we approach the implementation of LawTech and AI in legal practice in a cautious and step-by-step manner. In this connection, the DOJ has embraced the recommendation of the Consultation Group on LawTech Development to promote the use of technology in the legal industry progressively in 3 stages. In phase 1, we aim to change certain ingrained mindset and practices within the legal profession by raising awareness. To this end, the DOJ launched the LexGoTech Roundtable Series to raise the profession's understanding of LawTech and to facilitate the exchange and sharing of information between the profession and LawTech experts to enable them to plan for viable adoption of LawTech. Moving to phase 2, we aim to promote the profession's engagement with LawTech products. We hope that through the Hong Kong LawTech Fest, the legal sector could have a better understanding and access to the LawTech products which are available in the market, and to empower them to make informed choices on the adoption approach that best suit their individual needs. In phase 3, we would accelerate the widespread adoption of LawTech in the legal profession by encouraging local and overseas LawTech enterprises to establish and grow in the local market, thereby fostering Hong Kong's LawTech ecosystem. The Chief Executive Policy Address 2025 emphasizes the government's strong commitment to step up the promotion of AI as a core industry for Hong Kong's development. In this connection, apart from actively promoting the integration of LawTech and AI in the legal sector, the DOJ has taken on a pivotal role in shaping the broader legal regime for AI governance. In particular, we will establish an interdepartmental working group by the end of this year to coordinate responsible bureau in reviewing the relevant legislation so as to support and complement the development of and need for wider application of AI in Hong Kong. The emphasis of AI in the Policy Address 2025 resonates with the National AI Plus initiative. The 10-year blue plan for integrating AI into China's economy and society aims to maximize the technology's benefit for domestic development and international competitiveness. By aligning ourselves with this national strategy, and with Hong Kong being the springboard for mainland enterprises going global, we will strengthen Hong Kong's competitiveness as a global hub for AI development, as well as contribute to national development by powering up our legal services. As legal practitioners, it is our responsibility to harness the potential of LawTech and AI, not merely to enhance our practices, but also to contribute to overall development of our society. Embracing AI complements our vision of a forward-looking, dynamic legal system which is well prepared to tackle the challenges of the digital age. As we consider the implication of these goals for the legal profession, we must commit ourselves to continuous learning, adaptation, and collaboration. We should work together to ensure that the legal sector evolves alongside technological advancement while adhering to key principles such as accuracy and reliability, compliance with law and regulation, and security and transparency, etc. The AI revolution offers an unprecedented opportunity to redefine the legal profession and sharpen our skill. By embracing these changes with an open and cautious mindset, we can create a legal system which is not only swifter and smarter, but also fairer and more accessible for all. Let's ride the wave of this AI revolution together and seize the opportunities to enhance our practices and serve our community with greater impact. Together, we can keep Hong Kong at the vanguard of legal innovation in the 21st century. Last but not the least, I would like to take this opportunity to invite all those who are eligible to exercise your right to vote in the Legislative Council general election on Sunday. Your active participation is more than just an exercise of an important constitutional right, but a pivotal choice that will impact on the future of the rule of law and the general well-being of our society. Before I conclude, I would like to take this opportunity also to express my sincere gratitude to the supporting organizations, exhibitors of the Hong Kong LawTech Fest, moderators, speakers, my dear colleagues, and most importantly, all participants. None of the events of Hong Kong Legal Week 2025 would have been possible without your support, dedication, and hard work. And on behalf of the Department of Justice, I wish to extend my deepest thanks to all of you. Thank you.
Thank you, SJ. Thank you for the closing remarks, and please be seated. Ladies and gentlemen, the session of the AI era shaping the legal landscape in the 21st century is coming to a close, and this also marks the conclusion of the Hong Kong Legal Week 2025. Therefore, on behalf of the Department of Justice of the Government of the Hong Kong Special Administrative Region of the People's Republic of China, I would like to express our most sincere gratitude to all of our moderators, to all of our speakers for their thought-provoking and valuable sharing with us. We also extend our gratitude to each and every one of the guests that participated both in person and online with us today, actually all week long. Thank you very much. And also, everyone, please note that you can scan the QR code in the venue to complete the feedback form. And for online participants, you can do that online. Now, for in-person participants who require the continuing professional development CPD credits or advanced legal education ALE credits, please do present your QR code outside the conference hall to register your departure and to confirm your attendance record. And for those of you who was using the SI headsets, please leave that either at your seat or you can return that at the service counter outside. Thank you very much, everyone, for joining us today. We hope that you have enjoyed this week's event. Please stay tuned for the upcoming events, and we'll see you next year. And for those who are invited to join the dinner, please note that our shuttle bus will depart at 5:15 p.m. So therefore, please gather outside the main venue at 5 sharp. And as we have our staff that will be ready to direct you to the pickup point of HKCEC at Harbor Road entrance to take that shuttle bus. And we also cordially invite everyone to visit the HK LawTech Fest that is at S226, S227 after the event. Now, in case you haven't visited yet, the exhibition showcase the latest innovative products and the services from various technology providers. So therefore, everyone, please do take the liberty and pay them a visit and learn a bit more about the LawTech. Everyone, thank you again for being with us. My name is MC Melody. It has been my pleasure to be with everyone all week long. Thank you very much, and we'll see you all again soon.